Addition item 1.
Raman VC, if your lordship kindly permits. So here the appellant.
This is an appellate instance of husband being the appellant. No, on the argue Kurunanti.
Otherwise, there is another window of some other person.
Why are you appearing through VC?
But I have a little surgery done. So the doctors advised me not to go into humid conditions.
Okay, this is husband's appeal.
Husband's appeal.
Husband appeal against an order.
It's a proceeding for divorce, which has been dismissed.
Divorce application by husband.
Yes, ma'am.
It has been rejected.
It has been rejected.
What was the period of separation?
Its period of separation is since 1st of February 2016.
Then what is the date of marriage?
Whereas the date of marriage is 5th February 2015.
So hardly 8 months.
8 months. She has left.
8 months, the difference or dissension is not a condition to be considered for divorce.
What has happened in the meantime is that she had approached the Learned Family Court for 125 CRPC.
That will be automatic. How she will run then?
Now, that is exactly what I wanted to bring it to your lordship's notice. That in that proceeding, she was awarded 3,000 rupees as maintenance. Whereas the husband challenged it. This honorable court came to a particular finding that no, she has left her matrimonial abode without on her own accord and will. So therefore, that order was set.
That's right. That's it. That's an observation just in 125. That is not binding on us.
Absolutely, Vilas. I just wanted to bring it.
Then what is the meaning of raising all these objections?
Raising in the sense she has, if your lordship kindly.
Sorry, Mr. Misra, 5 months, 6 months of marriage of a girl coming to a completely different atmosphere. We don't appreciate it. It is to be a period to be construed for this irretrievable breakdown.
Your lordship will kindly see the conduct of the parties. But page 22.
But you will see alternately 7 years after. For taking her back, it's hardly 7 months difference.
Your lordship will kindly see her conduct, Lord. Page 22 of the brief. She appears in the
6 months, 7 months.
Mr. Misra, I mean, unless you know her from the before, I mean, the husband knows her from before, then only you have observed for 6 months. It's a life of 30 years.
Because I have tried taking her back. There was a public women commission.
Mr. Misra, so to understand a person flying to your house, close to your house rather, to understand a wife, what is the minimum period required?
Yes, definitely.
You must be in jointness. Your parents are there with you.
Yes.
So it is still yours. With today's culture and the development in the children, it is just difficult to even bear 2 years time to get into adjustment.
So that's what my humble.
All right. With all constraint we are admitting. Let us see.
Obliged.
Let us see how the matter leads.
My lord, obliged.
All for it,
True.
May I please your lordship?
Yes, again husband.
Yes, my lord.
What is the original application?
My
What is the
lord,
original application?
my lord, petitioner filed a civil proceeding before learned family judge Dhinkanal under section 6A and 13 of Hindu Minority and Guardianship Act, my lord.
The custody of child.
Yes, my lord.
Custody of child ହେଲେ ପୁରା ମାଟା ହଉନି ଏଟା ମାଟା ହବନି ଏଟା କଣ UAGA ନା କଣ କହୁଛନ୍ତି କଣ ଦେଲା ଷ୍ଟାମ୍ପ ରିପୋର୍ଟିଂ ସେଠି nomenclate କରିଦେଇଛି କଣ ତ it's a matter under provision. Yes, maybe this is matter is not maintainable. This is application under the Hindu Minority and Guardianship Act. Maybe lying to family court. So we asked the registry to have further stamp reporting.
My lord.
Original application since was under. The provisions of section 6 bracket A oblique section 13 of the Hindu Minority Guardianship Act may be in the circumstance lying to the family court. Matter may not be maintainable under this situation. Registry is directed to have further stamp reporting and place the matter accordingly. First case static के देखेंगे yes third one
Item 3.
May I please, your lordships? Your
yes please be on mic.
Your lordship, the petitioner has approached this court for obtaining the list of the workmen, your lordship, which was submitted during the time of reference, your lordship. At annexure 5, your lordship, the reference was
RTA application na co provision application that it will obtain list of workmen.
your lordship. Your lordship,
RTA?
No, your lordship.
Statutory achi. Straight away come to that unusual petition.
Your lordship, annexure 15, your lordship, may kindly see annexure 15. Page 198, your lordship. 198.
Annexure 15 टा आपण कोन आपन प्रोविजन पचरा होची को प्रोविजन रे आपण अप्रोच कले जो appropriate court को Annexure 15 कोन तार आंसर
Your lordship, the matter was pending before the tribunal, your lordship. I filed an application before the tribunal that when the
sir
reference
सेटा केते थर कहिबे sir under which provision you approach the tribunal for obtaining a list आपण माने जदि तो कोर्ट रेस्पॉन्स आपण रिपीट करिवे आपण को सबमिशन ता ना उत्तर देबे नॉले यू कैन टेक टाइम आल्सो
your lordship, I filed an application under
it's much better if you don't waste time. It's by repeating, just repeating, and then again I will repeat. I thought that you could not follow the question.
your lordship, may kindly keep the matter on next week, your lordship. I will prepare it better in a better manner, your lordship.
Yes, yes. What was the reference?
Reference to the tribunal, your lordship. Reference, the matter was referred to the tribunal, your lordship. By the state,
What is the reference? Matter was referred, that is understandable. What is the reference? Where is the reference?
annexure 5, your lordship. Page number.
So
Page number
reference,
34, your lordship.
reference is whether the termination of service of so and so along with so and so.
Yes, your lordship.
In the management of so and so, is appropriate or not, and what relief they are entitled to.
Yes, your lordship.
Then who are parties to the proceeding?
The work,
It is a proceeding being initiated by union.
yes, your lordship. In the reference, your lordship, the list of the employees was enclosed.
Idea, you know. Section 10, the procedure of CPC has to be followed. You sought for a reference?
Your lordship, conciliation proceedings failed.
So, how is it possible that without having the names and details of these workmen, you sought for a reference involving such a issue?
Your lordship, list was provided me to the conciliation officer.
Pardon?
List was provided by me to the conciliation officer, your lordship.
So
But-
that list is there with you.
Yes, your lordship.
So you go ahead with that list.
But when we filed that list before the tribunal is saying that we only will go by the list which has been submitted by the state government and not by the list which is being submitted by you.
Obviously, then where the challenge lies? Suppose in the reference order, there is a list of workmen,
Yes, your lordship.
not supposing, admittedly.
There is a list of,
Here a reference lies with a list of workmen.
yes, your lordship.
So your dispute lies with the list.
Yes, your lordship.
Then what should be the challenge?
Your lordship,
In the industrial adjudication, you will challenge that issue, or you will challenge the reference itself.
I have challenged before the industrial,
No, you can't. You can't challenge that issue before the tribunal. Tribunal is bound by order of reference. It's a matter referred to him along with a list of workmen to be adjudicated by him to give an award. So he is bound by that. Therefore, this is inappropriate proceeding. Suppose we do this, or we dismiss because that has been rightly rejected.
I will withdraw it, your lordship.
Yes, petitioner wants to withdraw the writ application with a clear understanding that the dispute raised through the application decided herein by the impugned order per se not maintainable. Well, dismissed as withdrawn.
Yes.
For orders item 4,
Item 4 में kindly taken up next week. Lord. Order 4 में kindly taken up next week. Lord. So lordships directed to file my petition. Lord, that man has come. Affidavit has to be filed by tomorrow. Lord.
Mr. Patnaik.
So lordship have already
It's a
directed
dispute
to
matter.
file a petition.
Sir, all right.
And copy serve kale other side.
18 तारीख रे मु कर दे
It's an inherent mistake.
आगे
It's an inherent mistake which cannot be cured by any application.
remediless है lordship called next week.
And matter pending for 11 years should not be cured.
But the earlier that
देखियो आसु 1 week after आसु
next week
is 5 type of just
lordship called next
one of
week.
the judge. One of the judge, namely Justice Biswanath Rath is not hearing.
Item 5.
Sri Prapullo Kumar Rath. The matter may be placed before Honorable Chief Justice for blessing in the bench. Justice Biswanath Rath being not a member.
This bench has passed the order. Lord. Item 4 Lord.
ନାଇଁ ନାଇଁ 5 କଲ୍ ହେଲା ଅନ୍ୟ ମନସ୍କ ରହୁଛ
କହିଲେ ପୁରା 1 week after
ଟାଇମ ହେଇଗଲା ଆପଣଙ୍କର ଯାହା ଚାହୁଁଥିଲେ ସେ ହେଲା
No, past your lordship has,
Other I am not hearing Mr. Ratha. Yeah.
Item 6,
May I please, your lordship?
So it will go to Chief Justice and then it will go to
Aye.
some other bench where I am not there.
item 6,
जो case उड़ा के your lordship is sending or any other court is sending that concern ବୋଲି, any other court my lord जे जाउची जे आमे सुनी बुनी जाऊ ବୋଲି सेटा सेमाने हेंडी पकेकी रखि दउछन.
That's your lookout. How to manage with those matters. Bring a complaint to Chief Justice if it is not listed. You are not remediless, madam.
इते आडे complain करू.
Yes, item 6.
Madam. Well, I have challenged the, my lord, the order of the family court. But here what has happened, my lord?
This matter has been admitted already.
Yes.
Miller.
All the parties have appeared.
Miller.
Yes.
Appeared.
Miller. This
Intervention
matter
will be
can be,
considered at the time of hearing.
Miller. It can be disposed of. Miller, the.
Can be disposed of because it has, what has happened, my lord?
Can be disposed of by a judgment or
No,
by
no,
a
no,
set-
not.
Remand, it can be
by a settlement.
remand, it has to be remanded. What has happened here, my lord? The lordship may kindly go through the order sheet.
Both
During-
sides agree for remand.
No, no, not. both sides.
Then please don't waste our time.
Miller.
You object to the remand.
No, no. We say your lordship may remand with a specific direction that he is to present herself in a particular date, Miller. Your lordship may kindly see the date.
She was expert.
No, not expert, Miller. She has participated.
Advocate died. The advocate.
She has some old lady standing behind. Please,
Miller,
please somebody give her seat.
Miller.
Please somebody give her seat.
She is the
Ask her to sit there.
She is the respondent, Miller.
She is the respondent.
Miller. The suit is for Miller. She is the first wife. Now the appellant is claiming to be second wife. Initially, she filed an proceeding before the family court.
If you fix a date and target the matter,
Yes, Miller.
Yes.
That your lordship may
Lordship may
kindly.
take 3 months or 4 months, whatever.
then
4 months or 6 months.
why remand is necessary? Is it?
Your lordship may kindly, that is what I am pointing out to your lordship, my lord.
Page 48, your lordship may see.
Lordship may say
One of the council, please.
Madam.
One of the council.
more percentage. I'm going
Hmm.
Page 48, my lord.
Yes.
The petitioner is present, respondent is
Yeah, please be on mic.
Uh,
Mic टा टिके down.
My lord, my lord. Sorry.
नहीं इतने down कर दो लिखो असुविधा. Yes.
The order dated 23/8, my lord.
Yes.
The petitioner is present, respondent is absent on call, no step is taken on behalf. The case.
Respondent was the wife.
Yes, my lord.
Respondent is the second wife.
Okay, second wife.
Miller.
Second way. Here, my lord,
Multiple lady. Second wife है वाला.
the hearing cannot be taken up due to absence of the respondent. Hence, evidence of the respondent is closed, put upon 2981-21 for argument. Without setting her expertise, directly put up for argument. And the judgment, your lordship may see the order.
By that time, the appellant's evidence was over.
Yes. And in the meantime, that
Okay, then this will
important
go back
fact
to
is
that stage. This will go
Yes,
back to
yes.
that stage.
the advocate had died. That is where no steps was taken.
Huh?
Advocate conducting the case died on 7/6/2021. I have filed the death certificate of the lawyer, page 53.
Okay, therefore
Therefore,
naturally,
this has
naturally the case went
Mal-
unrepresented.
and now the order your lordship may see at page 72.
अब order को काहे कीजिएगा?
से on contest लिखिदेले.
ହେଲା on content लिख देले.
On contest भी हब.
contest लिखिदेले.
Miller.
हाँ argument यही पेरिबो.
On
the
contest भी disposed because cross examination has been conducted
हाँ
by.
argument यही पेरिबो.
Again.
जेतिकी अछि तारी ऊपर यही
Right,
पेरिबो.
Miller.
But there is deprivation to one of the parties. He could not lead the evidence.
That is why I have said, my lord, that your lordship may remand But your lordship may kindly bear with me for 1 minute.
Yes, all right. She will
Milord,
present herself.
Milord.
She will present herself with a new set of counsel
Ah.
and the evidence will be completed within the time bound.
But one more thing.
That's all.
It is a property of the husband where a double-storied building consisting of 50.
Because if that part, Usuprak's part, has not been adjudicated, evidence has not been laid before the learned court.
Evidences are there. I am not spending your lordship's precious
Exactly.
time.
So if there is an observation that they are entitled for the entire Usupraks, or your client is entitled for the entire
The
Usupraks.
question is how much.
So as of now, there is no observation.
May I?
For us to interfere.
May I?
That is another aspect.
May I interrupt for a moment? There is another suit already been filed for that.
Milord,
There is an order in that suit. He is unnecessarily.
Your lordship, kindly
Unless the
see,
suit has been filed, the receiver has been appointed.
old lady
No,
for.
Mr. Pal, actually, this is the typical,
Yes.
delaying tactics. You see,
Yes.
the entire life she will lose and she will not
No,
get
no,
anything
already
out of that
he has-
two-story building.
He has filed the suit.
No, that suit is not progressing.
Yes, is already.
So why on your own you are not deciding?
Milord,
Why
There was
you
an
have the entire property?
There was an endeavor here, Milord, before this court, and both the parties had.
This is typical of civil suits for the generations
Yes.
together. You will never
We
get
have
it.
taken the step for
You
Malad,
see
the
our condition,
apportionment of the property.
It is
Here,
stated she's
but
now,
that
the
failed,
affidavit is that she's 70 or something, 75 or
Malad,
something.
both the parties.
73,
73.
17.
17.
Jone 6, Jone,
Now she's 78.
80. Now the lady is sitting.
Jone 68, 69, now Jone,
To that extent, Mr. Bhuya is right. She will never get it.
Jone.
never get
You
it
will
during the life.
successfully enjoy everything.
And
Claiming to be
you
second
will
wife
see,
and,
you will see her death.
Yes. That
That's
is
all.
exactly
And
the.
why a lady at this age, she will come run around for this thing. That is also a concern of the entire system. There we are faltering actually. Somewhere we are
Malad,
faltering.
we were ready for the settlement. And in fact, the
Arey,
proposals
you are
were
ready
filed
for the
here.
settlement, they will agree. You propose there that at least 50% or 30% or
We adjourn, we
That
adjourn
is
for
what,
10
that
days.
was
We
also.
adjourn for 10 days, come with a settlement here.
They did not agree, my lord. We had proposed, my lord, 60% and 40%. And with that, we will also give some cash, my lord. And that was, my lord, finally it was.
Yeah, 60-40 is a reasonable offer.
Your lordship, see,
And-
I have
and-
agreed for 50-50 million. I have agreed for 50-50
Black.
million. Your lordship, see the mediation report, see the
Okay,
order.
okay, all right, we make it clear. If you want a remand order, that's all. And we can simply observe any other application pending will be given a lawful disposal. That's all.
ଆପଣ 50 ରେ କାଇଁ ରାଜି ହଉନାହାନ୍ତି?
ଆଜ୍ଞା ମୁଁ 50 ରେ ରାଜି ଅଛି।
ସୁପାଲ
50
ନାଇଁ,
କରୁନାହାନ୍ତି।
ଦିଟା କେ ତିନି ମାଲା ତାପରେ 40% ପାଇଁ ଆଉ 10% ମାନେ we are proposing to give 5 lakh.
3 ମହଲା କି 6 ମହଲା ସେଟା କଥା ପଡୁନି କଥା ପଡୁଛି ଯେ ଆପଣ ଯୋଉ ଯାହା ବି ପ୍ରପର୍ଟି ଅଛି ଆପଣ 50% ନିଅନ୍ତୁ ସେ 50% that is fair enough।
ମାନେ ସେଟା
ତାପରେ ସେଥିରେ ଆପଣଙ୍କର earlier
ସେଟା ହେଇପାରୁନି ଆଜ୍ଞା
and
ସେ
listen
building ଦିଟା
to
ଅଛି
the proposition then you answer।
ଆଜ୍ଞା
earlier Usuprak's ର କିଛି mention ଅଛି କି 50-50 ରେ?
ନା
ନା ନା
then you are win-win ଆପଣ ସବୁ ଜାଗା ଯାହା ନବା କଥା ଯେଦିନ ନେଲେ future ରେ ଆପଣ 50%
କହି
ଦେବେ।
ଦଉଛି ଆଜ୍ଞା ଦିଟା ବିଲ୍ଡିଂ ଅଛି ଦିଟା ବିଲ୍ଡିଂ ରେ ଦି ଜଣଙ୍କର ଦିଟା ବିଲ୍ଡିଂ ଅଲଗା ଅଲଗା ହେଇଗଲେ ଗୋଟାରେ 60 ହଉଛି ଗୋଟାରେ 40 ହଉଛି ସେଥିପାଇଁ
ଆପଣ ଫାର୍ଷ୍ଟ ୱାଇଫ୍ or ସେକେଣ୍ଡ ୱାଇଫ୍?
ସେକେଣ୍ଡ ୱାଇଫ୍।
second।
ନହେଲେ ସେ ବଡ
So
ବୟସ
therefore
ତାଙ୍କର ଅଛି।
ଆପଣ ବଡ ଭାଗଟା ନେବେ। Read together with the order sheet dated 23/8/2021 in the CP 576 of 2017. This court finds there is clear statement that the lawyer appearing for the respondent therein died just before this date. And there was reasonable cause for absence of the respondent not being represented by the counsel. The order dated 23/8/21 reads as follows. The order appears to have been passed for non-cooperation of the lawyer who had already died on the date fixed. It is at this point of time, this court finds Judgment টা কোথায় আছে?
Again,
Ajay,
judgment.
annexure,
Maybe on
Page
7/6.
72, your lordship, I'm
The-
sorry. Page
50
7621 is the
my lord,
7621 say he passed away.
my lord, my lord.
But my evidence
Have
closed
died
since
on
10/1/2020,
Okay,
10th January.
it is at this
After the
point of
COVID ପାଇଁ
time,
ବନ୍ଦ ରହିଲା
court
ପୁରା।
find from the final judgment dated 29/10/21.
Operative 72, page 72.
Huh?
Starts from page 54, ends in page
Yes,
7.
I am holding that,
Yes.
please. There is, however, recording, the matter has been decided on contest of both parties. Sri Pal, when claims, when doesn't dispute, there is no participation of the respondent on 23/8/21. Sri Bhuya, however, claims, appearing for the opposite party herein, however, claims there may not be wrong in the mentioning in the disposal of the proceeding on contest of the parties, as there is a possibility of participating to the extent of evidence recorded and making submissions. This court, from the order dated 23/8/2021, finds there has been no advancement of evidence on behalf of respondent at all. This is a interstate dispute between the appellant and between the petitioner and the respondent in the original proceeding. Undisputedly, there has been no proper contest at the instance of the respondent. This court thus finds in the resolution of an interstate dispute, there must be active participation of the respondent also. We find there is reasonable cause in the non-appearance of the counsel for respondent who had hardly died on so and so, and there has been no substitution of counsel. Maybe for the reason respondent did not know the death of our counsel. Okay, this court find there is reasonable cause in the absence of the respondent. Further, since there is no properly contested disposal involved herein, this court interfering in the impugned judgment annexure
6.
6, set aside the same to afford proper opportunity and to have for the ends of justice. The civil proceeding 576 of 17 is remitted back to the Judge Family Court, Bhubaneswar, for fresh adjudication of the proceeding. For there is suffering to the petitioner for no responsibility of her. This court direct the petitioner herein,
Appellant.
appellant herein, to appear before the Judge Family Court, Bhubaneswar, on 18th of July, along with our affidavit in evidence in affidavit.
Certified copy টা বার করি।
On the date on 18th, the matter will be posted before the family court, Bhubaneswar, And after affording opportunity of cross-examination to the the
This one.
petitioner therein, the respondent herein, there shall be attempt by the family court to conclude the whole proceeding at least within 3 months of the date of appearance. Next para, it is at this stage of the matter this court find there is a miscellaneous application pending here.
I number 151.
Kete miscellaneous application? R. 151 of 23 with the following prayer. This court considers this application feels it appropriate to have an interim arrangement on the basis of request involved herein, particularly keeping in view that the petitioner in the trial court is already approaching 80 years of age. Similarly, the respondent there in the appellant herein also approaching 70 years of age. Okay, to look into the age of both parties.
ऐसे पिटसन कॉपी देई नांती मते
I last time counter दबा पे. Come on.
Both parties.
ना मते देई ना
We don't enter into ultimate without prejudice to the claim of the party
Not entering what
to
fell
be
from
thrashed
Mr. Pal,
out.
we are just going by that.
to
It
be
fell from
thrashed
you.
out in the trial court
आगे
without entering into the rights and contentious of either parties and leaving the matter to be finally adjudicated, such dispute to be finally adjudicated in the trial proceeding by the family judge Bhubaneswar. This court simply observe till an outcome in the CP 576 of 17, along with an outcome on the controversy involved herein. Both parties, the usufructs arising out of property involved herein shall be enjoyed in 60 by 40% respectively. 60 meaning thereby 60 in favor of the petitioner and 40 in favor of the respondent for the time being.
ଆପଣ ସନ୍ଧ୍ୟାରାଣୀ ଆପଣ
ଆଜ୍ଞା
ଠିକ ସନ୍ଧ୍ୟାରାଣୀ ହଉଛନ୍ତି appellant
ଆଜ୍ଞା
and
ଆଜ୍ଞା ପିଟସନର ହୋଉଛନ୍ତି
petitioner IRA petitioner ଆପଣ
हां
आगे.
आयर as well as
ଅନୁସୟା
ଅନୁସୟା.
as well as in the family court
ହେଲା ସେଟା petitioner in the
ସେଇଟା ହେଲେ ଫେର ଆଉ ଥରେ ଆପଣ ଆସିବେ ଠିକ
Petitioner
ଏଠି ଆପଣ
in the
କିଛି
trial.
ପେଣ୍ଡିଂ ରଖିବାର ନଥିଲା
petitioner in the trial ହେଲା and respondent in the trial. ସେ ଯୋଉଟା ଲେଖା ହେଲା 60-40 to be enjoyed by so and so draft କରିକି ଦେଖା ଗୋଟେ short
नाटा लिखि देले भलो ना लिखि देन सब बेटर हम
ହଁ ନା ଲେଖିଦେ ସେଠି ଲେଖିଦବ ନାଟା ଆଉ ବ୍ରାକେଟ ରେ ନା ରଖି
May I have a say, my lord?
ଆପଣ କିଏ
ସିଏ ହେଲେ
ସେଟା
ଭାଇ
ହେଲେ ଦିଟା ସ୍ତ୍ରୀ
brother.
Sir, what has happened?
Husband's brother.
What has happened is just
no
directed
no
at
we outrightly reject this is
No,
not within the parameters of the
my lord,
constitution.
your lordship says say
Okay,
that
sorry,
till the this was-
you go fight out in a civil litigation.
my lord, in actually in
Intervention
respect of the very
ଆପଣ
same
କାହିଁକି ଏଠି ସପୋଜ ସମ୍ ଅବଜରଭେସନ ଇଜ ମେଡ୍ ଆପଣ ଯୋଉଟା ଅରିଜିନାଲ ଯୋଉଥିରେ ସୁଟରେ ଆପଣ ଇଣ୍ଟରଭିନ କରିବେ କି ନ କରିବେ
yes yes
that will be impacted
I
ଆପଣ-
advise accordingly.
So that is the short proposition fell from my lord ଆପଣ ଯୋଉଠି ଯାହା କରିବା କଥା କରନ୍ତୁ ଏଠିରେ କଣ already
ठीक है okay for the IA for intervention देखो 110 of 23 since a request herein since involved outside the jurisdiction in CP number so and so, this court feels it appropriate to not to entertain such application. Rejection of such application, however, may not stand on the way of the party concerned to have his litigation in appropriate forum.
in fact when the suit is pending and the order of status quo was also there.
Man go, old woman go with happiness. तब बुझे दियो तो order.
My lord, there is a content petition.
Hey, contempt drop कर दो चु.
Again.
Yes, as an outcome of this proceeding. Main proceeding, matter 96 of 21. The contempt 18 of 22.
Again,
Drop.
ଆଜ୍ଞା ଡ୍ରପ୍ କାମ ଆଉ ସେ ଚାहे କିଛି ଯୋଉ ଅର୍ଡର ବଳ ଯାଇକି ସେଠି ପୁଣି ଉତ୍ପାତ ହଉଥିଲେ ସେଗୁଡା କରିବୁନି
ଆଜ୍ଞା କିଛି ନାହିଁ ଶୁଣନ୍ତୁ. We don't know while come.
ସେ ପୋଲିସ
going
କେସ୍
back,
ଯାଇକି
she will be
ଆପଣ କିଛି
serving-
କରିପାରିବେନି ଏଥିରେ ଆଜ୍ଞା ସେ ଆପଣ
I think 7 please, Lord. Lord, sir, I'm on busy.
Condonation of delay.
Yes, Lord, so 125 days of delay, Lord.
You are on
Second
BC.
appellant is what? Yes, Lord, so I'm on busy.
Notice ଯାଇଛି?
No, Lord, sir, notice has not.
Okay. Okay, let us find you are the wife.
Yes, Lord, so I'm wife.
Okay, what is the delay? 74 days, all right. Issue notice in the matter of limitation along with copy of the matrimonial application. Requisites being filed by Monday. Notice we issued in the limitation matter on the respondent hearing, fixing short returnable date. The limitation application may be posted immediately after appearance of the respondent hearing.
For admission item 8,
Noted, my lord.
Last occasion, you should directed the husband to produce his property as well as his income slip and the income certificate from the employer. I have intimated
Other day this matter was there.
Yes, Your Lordship. Your Lordship already expressed the view that because the daughter is 17 years old and next year she will be an age of she will be attained the age of marriage. For that purpose, Your Lordship directed me to convince the husband.
Property statement ଦେଇଛନ୍ତି?
ନାଇଁ ଆଜ୍ଞା ମୁଁ Sunday ତାକୁ intimate କଲି but he told me that his mother is suffering and she is in deathbed.
Pardon?
He intimated me that his mother is suffering from old age ailments and she is in deathbed. ତ ଦେଇପାରିଲାନି ଏଥିଲାଗି ମୁଁ କହିଲି କୋର୍ଟ ଦେଇଛନ୍ତି
କାଇଁ ସେଇଠି affidavit କରିଦେଇ ପଠେଇ ଦେଇ ପାରିବେନି?
ନାଇଁ ତାକୁ କହିଲି ଏଥିଲାଗି ସେ ନିଜେ ଆସିଛନ୍ତି personally ମୁଁ କହିଲି ଆଜ୍ଞା କୋର୍ଟକୁ ମୁଁ ଟାଇମ ମାଗିବିନି ଏଇ ଜିନିଷରେ even I support your lordship's view.
ନାଇଁ why don't you advise him to prepare the affidavit there and send?
ଲୋକାଲ କାଉନସିଲ କୁ କୁହନ୍ତୁ
ଆଜ୍ଞା ସେ ଆସିଛନ୍ତି ନିଜେ
We are directing
ଆଜି ଆସିছে and this is workman
Yes, my lord.
who appears for the management.
I am appearing.
You are there. So what was the dispute?
My lord,
Reference, rather
termination, my lord.
reference?
Termination of the workman.
Huh?
Termination of the workman.
Termination of the workman.
My lord.
And it has been
It has been
awarded in favor of the management.
yes, my lord. Relevant portion, my lord, may I pray that annexure 12 is the award and relevant portion is at page 37, my lord. So far as jurisdiction party is decided that, my lord.
So this has been dismissed only on the ground of jurisdiction issue.
Yes,
So
my
that on merit also, page
No.
36, para 10, On merit also.
It is labor court, Sambalpur.
Yes, my lord.
Yes. He was transferred, he didn't join, therefore he was terminated. He was transferred to Mumbai, Surat, my lord. He didn't join. He took
Just
different leads.
1 minute. This is a company in Keonjhar.
Yes, my lord.
And
So
company
management company in Keonjhar.
headquarter in Mumbai, my lord.
Huh?
Headquarter in Mumbai.
ସବୁ କମ୍ପାନୀ ତ ଥାଏ ହେଡକ୍ୱାର୍ଟର ଅଲଗା
ହଁ,
ଜାଗାରେ
ସେଟା-
they have ଟାଟାର ହେଡକ୍ୱାର୍ଟର କୋଉଠି
Just
କେଉଁଝର
one-
ଯୋଉ ଟାଟା ଅଛନ୍ତି ଆର୍ସେଲର ମିତ୍ତଲ ତ ଲଣ୍ଡନ
ତାହେଲେ ଟାଟାର
ଏ ଲଜିକ ଯଦି ଆମେ ଆପ୍ଲାଏ କରିବୁ ତାହେଲେ ତ ଆଉ
ଟାଟା
ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ
ପଳେଇବେ ସମସ୍ତେ ସେଠିକି।
ନାଇଁ,
ଟାଟାର
company
ତାହେଲେ-
ପଚାର କୋଉଠିକାର company ହଉଛି ବମ୍ବେର।
ଥାପର ଗ୍ରୁପ ଏ ଯୋଉ ଲିଡିଂ ଡିସିସନ ଗୁଡାକ ଅଛି ତ କୋଉଠି ଏମିତି କେବେ ହେଇନି ଯାହା ଆପଣ ଲେବର ଲ ରେ
ଆପଣଙ୍କ ଆପଏଣ୍ଟମେଣ୍ଟ ଅର୍ଡର ଏକ୍ସିକ୍ୟୁଟ କରିଥିଲେ ଏଲସିଆର ଆସିଛି କି?
ଆସିଛି।
Appointment order is matter, my lord, annexer,
ଟର୍ମିନେସନ ଅର୍ଡର ଆନିସ
termination order, annexer 8, my lord.
ପେଜ କୁହନ୍ତୁ।
Sorry, 9, my lord.
9.
Annexer 9, page
Page-
24. Page 24,
24.
my lord.
ଏଟା କୋଉଠି ଇସ୍ୟୁ ହେଇଛି?
My lord, this has been the termination order issued.
ଯୋଡାରୁ
by-
ଇସ୍ୟୁ ହେଲା।
Yeah,
Issued at ଯୋଡା.
issued at Jordan.
Okay, now he refers to some transfer there.
Yes,
Where
that
is the transfer order?
my lord. Order of transfer is at, my lord, annexer 3, page 18.
It is issued at Joda.
My lord. Thereafter, on inquiry was conducted, charge sheet was issued.
Joda to join at
My lord, Porbandar.
Subuni.
Porbandar,
To join at Porbandar.
my lord.
You registered this transfer.
Registered and there,
That's the cause of action.
no, thereafter charge sheet was issued and
Charge
thereafter
sheet on what? On absenteeism.
on absenteeism.
On absenteeism. So as an outcome of that.
My lord.
So there is clear jurisdiction, Mr. Jana.
Yes, madam, but Lordship में the
He is
condition,
yet to join the other end.
the condition, your Lordship में see annexer 2, he himself agreed that in case of any dispute, the jurisdiction will be at Mumbai. Your Lordship में see
Pardon? Annexer 2.
annexer 2,
Huh.
annexer 2, annexer 2, page 13,
Page?
13,
ये
13,
बाइक ऊपर रुहंतु माइक ऊपर
13, 13,
पेज 13
page 13,
yes this is company letter
yes, yes.
The relevant,
He has agreed. And page relevant portion is page 17. Page 17. 17.
Mr.
clause-
Jena, by agreement, can you confer jurisdiction? That's a very old case law.
Well, that is what my case.
No, by agreement. So by agreement, can you confer jurisdiction in Mumbai court?
But he
You
has
see, then
agreed.
Mumbai court doesn't have extraterritorial jurisdiction, it will be. Because the cause of
Mumbai
action,
court will refuse.
which they will refuse.
Sorry Mr. Jena, we are closing.
As your Lordship passed
Had-
order, your Lordship
had.
may
You should
refer
have
my
advised actually your client. Because you can't confer jurisdiction by agreement in Mumbai or any
Okay.
Porbandar.
He must not be the lawyer in Sambalpur.
Sambalpur, he
So
has.
Sambalpur रे से lawyer देखले जाऊ हाई कोर्ट जीवो ये तो कोसला साग कियारी एठू जीवे ना ऑफिसर एठी काम करतला
ସେମାନେ ଏଇ କ୍ଲଜ ଟାକୁ ରିଲାଏ କରୁ
ଜଜମେଣ୍ଟ ହବ ହେଲା ଗୋଟେ ସାଇଡ ରେ ଇଏ ହେଲେ ପାଣି and other side ରେ ପ୍ରଶାନ୍ତ କୁମାର ଜେନା repetition arises out of repetition involve a challenge to the impugned order dated 17/5/2017 passed by
Jurisdiction ଟା କୋଉ provision ID Act ରେ?
My
Section
lord.
section କେତେ?
Idea.
So far,
Jurisdiction.
jurisdiction, my lord, here, my lord, jurisdiction is about the appropriate government. The appropriate,
ଏଥିରେ refer ହେଇନି?
my lord, I am reciting a decision, my lord.
It is arising out of a reference, no?
No, it is under section 2A.
For two, direct challenge,
Yes.
right? Yes, passed by presiding officer, Labour Court, Sambalpur in ID case 9/16. Background involving the case appears to be. Vasant, please take your seat, both sides. Petitioner having typing skill was appointed by opposite party management on 14/9/98 under the terms and conditions Annex 1. While petitioner was continuing as typist, management, considering his expertise, promoted the petitioner to the post of accounts assistance with effect from 1/4/2008 and posted in its office at Joda, in its operation unit at Joda. Copy of order of promotion appears to be dated 31/3/2008 at Annex 2. It is while the petitioner continuing as such petitioner got a communication by Annex 3 dated 21st May 2015. Transferring the petitioner from Joda branch to Porbandar branch as administration assistant with effect from June 1st June 2015. On the petitioner registering such transfer in a development at the instance of the management, proceeding was initiated against the petitioner based on a charge sheet being framed. Petitioner was subjected to termination involving alleging illegal termination. Petitioner brought a dispute under the before the presiding officer, Labour Court, Sambalpur, under the provisions of section 2 bracket capital A, then again 2 of the ID Act, 2A2, questioning the illegal termination and requesting therein for a direction for reinstatement of him in the service with full back wages. The petitioner in his statement of claim submitted while reiterating the aforesaid developments, submitted his objection to the refusal of engagement and or the termination order involved herein. There is further disclosure by the workmen that even though such resistance was brought before the district labor officer, and the Assistant Labour Commissioner, none of them given any outcome, compelling the workmen to take shelter of the Labour Court. First party management on its appearance in the industrial adjudication ID case number 9 of 16. While registering the claim of the petitioner, contended there is good ground in terminating the services of the petitioner, and that too after entering into disciplinary proceedings, providing opportunity to the petitioner. Management also took stand. Petitioner not joining the transport place amounted to misconduct and violation of conditions in the conditions of service. Management also challenged the entertainability of the dispute on the premises of jurisdiction based on the transfer order, particularly keeping in view that the petitioner since was transferred to Porbandar. Therefore, cause of action lied that he within the jurisdiction of Maharashtra and not in Orissa, state of Orissa. Hearing the parties and parties also advance their evidence in the industrial adjudication, considering the contentions, plea of the party and on examination of evidence by the impugned award and its 12. Labour Court Sambalpur has come to dismiss the section 2A2 application of the ID Act application on the ground of jurisdiction alone. Counsel appearing for the petitioner taking this court on reiteration of the factual narrations and the development taking place until the petitioner was thrown out of service. Taking this court to the development through Annexure 3 as well as 4, contended promotion order as well as transfer order being issued at the end of Joda in the state of Orissa, coming within the jurisdiction of the Labour Court Sambalpur. Petitioner resisting such transfer, cause of action, if any, completely directly related to a cause of action taking place at Joda branch office and but within the clear jurisdiction of the Labour Court Sambalpur. The Jenna, it is in the premises, counsel for the petitioner claims the impugned order Annexure 12 should be interfered and set aside, and as an outcome, the matter should be remitted back to the Labour Court, Sambalpur, for adjudication of the dispute therein. The Jenna learned counsel appearing for the management, however, while not disputing on the issuing of original appointment order along with the orders at Annexure 3 and 4 being issued from Joda office and petitioner registered while continuing in his service in Joda. However, taking this court to the plea of the management through the written statement in the forum below, taking this court to the conditions of service emanated through Annexure 2 contended for petitioner consenting to the jurisdictional aspect dispute, if any, between parties requiring to be decided in the jurisdiction of Maharashtra, contended there is right decision of the industrial adjudicator. कौन कहउचंदी
सर एटा जो आपण कहले जे मु कन्सीड कले एटा सर अनेक्स 3 टा
नहीं सेटा
जोडार इश्यू हेनी
आपण कन्सिडर करना आपण कंटेंशन टा एबे रेकॉर्ड हेछि सेटा
नहीं सर
दैट विल बी टेकन केयर ऑफ
हां से जोटा अनेक्स
आपण सबमिशन पर एबे रेकॉर्ड हला
3 टा सर जोडार नु अनेक्स 3 टा जोडार इश्यू
all right
मिस्टर जेना देयर इज अनदर
एटा
एस्पेक्ट
एटा इश्यू हेछि
कलिकता
कलिकता so not from Maharashtra even
that
and 17 talks about breach of contract and jurisdiction
सेटा को जीवो
so सेटा आपण इंडस्ट्रियल ट्रिब्यूनल आपण पर्पसफुल से लेखा भी हेनी any industrial dispute arising out of employment shall Bombay court has shall jurisdiction because that on the face of it will make it good I mean redundant or illegal
माने they will misunderstand me the company will say that it was never
आपण सबमिशन एबे रेकॉर्ड हला
हां सर
सेटा तांको सबमिशन
रखिता ब्रैकेट रखिता जे Annex 3 टा issued हेछि from Calcutta office परिवा से consequently correction
आपण कॉन्सेशन नो बट यू कैन डिस्प्यूट दैट ही वाज एम्प्लॉयड एट जोड़ा registered at Joda
yes
and he received the order at Joda alleged occurrence of misconduct of disobedience non is also at Joda
yes that
see part रे लिखा है factual
that is on this
considering the rival contentions of the parties, this court while finding petitioner's appointment, original appointment was in the office placed at Joda of the management placed at Joda is promotion also made in the office of Joda. The transfer order also took place while the petitioner was continuing at Joda. Not only that, even though, even though this court find the head office of the management establishment situates at Maharashtra, Bombay, na? Bombay head office in Bombay in the state of Maharashtra. But the operational jurisdiction of the petitioner remained in the office of Joda. There has been several correspondences being issued also from the office of Joda at different point of time. Petitioner also submitted his residence in the Joda office. Further considering the objection raised by the counsel for the management through provision at clause 17 of the Annex 2, this court find the provision reads as follows, page 17. Keeping in view, keeping in view the rival contentions, this court finds law on this issue, on the issue of jurisdiction has been clear by this time, observing by agreement there can't be enforcing jurisdiction on a party. Further, for the clear disclosures herein above, right from employment till the transfer, the petitioner, all actions all involving the petitioner are taking place in the Joda office. In the circumstance, this court find it may not be a case that there is absolutely no cause of action in the state of Orissa. Law is also fairly well settled, observing even a part of cause of action also can give a jurisdiction to a court or authority in particular state. This court also finds, since this is a labor dispute, under the provisions of the ID Act, the section 2, subsection 2A, sorry, section 2, capital A2. The appropriate government is state of Orissa. Okay. In the whole background of in the above background, this court find there has been wrong appreciation of the issue involving jurisdiction with the labor court involved herein. This court, while declaring the finding and observation in taking out the jurisdiction of the labor court at Sambhalpur, runs back, interferes in the order, in the hour, annexure 2, award in ID case number 9/16, annexure 2, set aside the same as there is necessity for lawful adjudication of the dispute involved herein. This court remit the ID case number 9/16 to the labor court Sambhalpur for giving a lawful adjudication to the dispute involved therein. This court further direct both the parties to appear before the labor court Sambhalpur along with the judgment of this court on 20th of July to take further instruction on the further proceeding involving the dispute involved herein. Read petition succeeds. And however, in the circumstance, however, there is no order as to cost. That's all out of the story. Yes, Kali, court master. Kali list
Again.
for admission, 10 ru au jaha rohila setiki rohibo. So that we will be in a position to finish up these cases. Thereafter, we will go to any further case.
Again.
Okay.
Again.
Yes, rest cases will come tomorrow.
Item 12 millers.
Withdrawal.
LCR is required millers. So that's
Withdrawal.
12. LCR
Withdraw
is.
karibe.
I am for the opposite party. LCR is required in that case.
Court are?
Item 12.
12 re kon hela?
LCR required millers. LCR required millers. LCR. Lower court record.
Required. LCR पढ़ू देखिवा से पढ़ले देखिवा LCR दरकार कि नहीं
आगे
काहे आपण दौनाते कॉपी जोटा डॉक्यूमेंट रेफर करिवे
चल मु फाइल
आईडी
करी
केस तो
चल काउंटर गोटे फाइल करी
आईडी केस तो
आगे
Yes, sir.
आईडी केस हेले जे फाइल करचंदी से आनी नथिवे सर्टिफाइड कॉपी ऑफ ऑल डॉक्यूमेंट्स एविडेंस
फाइल करना नहीं होता
आसे देबे
आगे
get ready with the copy of each document
As your lordship.
hela
Yes.
and it is not believable that a dispute, a repetition arising out of a dispute in absence of getting into all documents.
Yes, sir. So I need some time to file all those documents.
କାହିଁକି ଆପଣ ନ କରିକି କାହିଁ ରିଟ୍ ପିଟିସନ ଫାଇଲ କଲେ ଆମେ ୱିଡ୍ର କରିଦଉଛୁ ରିଟ୍ ପିଟିସନ ଆପଣ ଯେତେବେଳେ ଡକ୍ୟୁମେଣ୍ଟ ପାଇବେ ଫାଇଲ କରିବେ
No, lordship, I have next.
so you want to say that you have filed a writ application without possessing the
No.
document?
I have filed the judgment copies and other
କାହିଁକି
copies
ଖାଲି
before the
judgment
lower
ଧରି
court
କେମିତି
which I have
file
filed.
କରିଦେଲେ? ଖାଲି judgment ଧରି କେମିତି
No,
writ
no,
petition
your
file
lordship. I have
କରିଦେଲେ?
also filed the civil suit judgment and also the plaintiff petitions.
Evidence file କରିଛନ୍ତି?
Yes, your lordship.
କରିଛନ୍ତି ତ?
Yes, sir.
ତାଙ୍କ evidence ଟା file କରନ୍ତୁ।
ଡକୁମେଣ୍ଟ
ତାଙ୍କ evidence ଟା file
ଏକ୍ସିବିଟ ହେଇଛି ସେ ଡକୁମେଣ୍ଟ ର କପି ରଖିଛନ୍ତି ନା ନାଇଁ?
I will brought it from my client, so I need some time.
ଫାଇଲ ରେ ଦେଖିଲେ?
ନାଇଁ ସେଇଟା ନାହିଁ ଆଜ୍ଞା ଯୋଉ
ଫାଇଲ ବି ନାହିଁ।
ନା
ଆଉ ଆପଣ କାହିଁ ଆସିଛନ୍ତି କୋର୍ଟକୁ? ସିନିୟର ମନା କଲେ ଫାଇଲ ନେଇକି ଯା ନା କାଳେ କହିଦେବେ ଆର୍ଗୁମେଣ୍ଟ କରେ।
no lordship.
ଆଉ ମନା କଲେନି ସାର୍ ସେଇଟା ସବୁ ରହିଲା ରେଷ୍ଟ ଅଫ ଦି କେସ୍ ରିମେନିଂ।
ସାର୍ ଗୋଟେ ଗୁହାରି
ଚ୍ୟାଲେଞ୍ଜ କରିଦଉଛନ୍ତି।
Your lordship may give me leave to make a mention.
କଣ କୋଉ ମ୍ୟାଟର?
Item 16 ମୋ ନାଁଟା ଆସୁନି ଆସୁ ମୁଁ appear କରିଛି 27 ଜୁନ।
16 ରେ ଆପଣ ଭୋକାଲାତ ଦେଇଛନ୍ତି?
ହଁ ମୁଁ ଦେଇ 27/6 ରେ ଦେଇଛି।
16ଟା ଆଉଟ ଅଫ ଲିଷ୍ଟ। ଓ ସରି ଜଷ୍ଟ 1 ମିନିଟ ये 14 to 16 ଆଉ କେତେ ଅଛି ଆ ପରେ? हाँ 14 to ये कर दियो 18 आउट ऑफ लिस्ट हबो हैला। यस सर गोज आउट ऑफ लिस्ट। एइथिरे खाली गोटे लेखि दबो ए जो 18 रे there is allegation by Sri Mishra. Yes,
ମାନେ 16 ମୋ
16
ଆଜ୍ଞା
sorry 16 ରେ ଆପଣ का पे appear करछंती?
ରେସ୍ପୋଣ୍ଡେଣ୍ଟ ଜଣେ ଆଉ
wife
ଆଜ୍ଞା
in spite of his
both
filing
appeal
appearance
ହାଜର ହେଇଛି
for the
27।
wife involved herein, his name is not being reflected in the list, creating inconvenience in the counsel in attending to the case. Registry directed to find out the appearance memo, Bhokalatnama if any, of the counsel Sri Siddharth Mishra and reflect his name in the next listing of the matter.
Milord, it is a covered matter. As per the guidelines of our
आगो condonation delay कौन इतरे repeat रे condonation of delay 21 मसिया matter केबे रो cause of action केबे रो की
2013 rejection.
हाँ सेया
Annexure 1.
covered मैंने जो honorable chief justice का order and more order. Let him get the benefit what is there. More order दियंतु. Without expression of any opinion rocks to yeah.
So page 21 is reject because he could not produce any document, and that's a land recorded in favor of the government. J department रो जगह से किसी देखे ही
यदि किसी record दे परिवे without expression सेति पे हम
हाँ क्या
Item 2, may I please your lordship. Annexure 7, page 74 is under challenge. 15B order.
This matter was listed earlier.
My lord.
हाँ आपण cover କରୁଛନ୍ତି case.
My lord, it is covered under Vibhuti
15B. 15B रो order टाइप challenge କରୁଛନ୍ତି.
दिया covered माने कौन एटा notice issue is ना final order.
Final order.
Final order.
देखियो ताले दियो तो कौन
In Sabak settlement, the land was recorded in Sarod.
साबक हाल
के खाली गोटे कॉपी टा देला आसु कॉपी टा दियो तो कौन टा
कॉपी दियो
ना
place the matter on Monday. In the meantime, let there be service of copy of the judgment seeking coverage of the with the case at hand.
We have already served the copy of judgment. Last date is
Judgment रो टा copy टा दे दियो तो next.
Item 3,
এটা সেই ଯୋଉ ଆମେ ମିଷ୍ଟର ବୋସ୍
ଆଜ୍ଞା
ଏ ଯୋଉ କେସ୍ ହଉନି ଯେ ଆଗରୁ ଶାବ ଖାଲରେ ଡିସ୍କ୍ରିପେନ୍ସି କରିଦଉଛନ୍ତି
ଆଜ୍ଞା
ସେଇ ଲାଇନ
ତାହେଲେ ଯଦି କରିଦିଅନ୍ତୁ
ଆଉ
dispose।
ଗୋଟେ ଜିନିଷ ଥିବ ଦେଖେଇଲ ଫାଇଲ ଟା ଆଉ ଗୋଟେ ଜିନିଷ ଥିବ ସେ ତହସିଲଦାର କୁ ପଠେଇ ଦେଇଛନ୍ତି କି
No, my lord.
15B order annexure 8
7, page 74. Annexure 7, page 74.
74 ମୋର ତ annexure 8 ହେଇଗଲା 73 ରେ
74 पे ମୋ brief ରେ 74 ଅଛି last page ଟା।
Page 7.
ମୋ ବ୍ରିଫ ଦେଖଉଛି ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି 6/1/23 ର ଅର୍ଡର
ଏଟା ସେ
My
ସାରଦରୁ
lord.
ସେ ଜଳାଶୟରୁ ସାରଦକୁ କନଭର୍ସନ କରିବା ପାଇଁ ମାନେ ଚେଞ୍ଜ କରିବା ପାଇଁ କିସମ ଟା ସେଟା ରିଜେକ୍ଟ ହେଇଛି।
ରିମାଇଣ୍ଡ କରିଦବା ଟୁ
ଆଜ୍ଞା
କନସିଡର
ଆଜ୍ଞା yes
in
yes
the light of
କାଲି
this judgment
ଆଜ୍ଞା
had the submission of respective counsel involving the order dated 6/1/2023 in the course of submission this court find petitioner has a prima facie case and likely to be covered under the judgment of this court in WPC 14368 of 22 judgment oblique order of this court. It is in the process this court setting aside order dated 6/1/23 remit the matter back to the additional commissioner bracket additional regional court कोठी करे ये
Bhubaneswar, OP3. Khordha matter.
होता for readjudication of the 15B proceeding 15B of OSS proceeding while also keeping in view the judgment oblique order rendered by this court in WPC number so and so by completing entire exercise within a period 3 months from the date of communication of order by the petitioner.
item 3,
May I please, Lord? Lordship, may kindly see order number 1. Lordship was pleased to issue notice. What has happened in this case, my lord? The petitioner faced a criminal prosecution under section 13 of the Prevention of Corruption Act way back in 2013. In 2018, it ended in acquittal. At the time of investigation, his original service book was seized by the CBI, and thereafter it has been kept with them. And your lordship would see under Annexure 4, pursuant to my acquittal in the case, Annexure 4, my employer has asked.
What are you challenging now?
Over here, madam, I'm seeking a mandamus to return the service book because there is no purpose in keeping the service book. My lord, I've relied on a judgment of Kerala High Court where it has been categorically held that only if there is a forgery in the service book or there is a misrepresentation.
You are already acquitted. There is no
Acquitted,
further
madam.
litigation.
There is no further. They preferred an appeal. An appeal is not yet admitted, madam.
Appeal?
They have preferred an appeal against the order of acquittal before this honorable court. Appeal has not yet been admitted. In fact, your order number 1 is very clear.
Acquittal, order of acquittal when? 18?
18, my lord.
Appeal preferred when?
In 2000, almost after 1 year, 2019. Until date, it
That has
not
not been admitted as of now.
Your lordship order is very clear. Order number 1.
So the prayer of my learned senior so far as opposite part number 3 is concerned, I require 1 week time.
Okay, this could record the submission of Sri Ray that in a CBI proceeding, petitioner got acquitted by the judgment of the competent court dated 24/12/2018 in TR 13 of 13. There is clear statement even though an appeal has been filed against such acquittal order and judgment. Since 2019, the appeal has no appeal number kete?
Appeal number, my lord.
Slip re lekhi diyandu.
Again, I've written.
This appeal is yet to
CRLP.
The PP Mahanti learned counsel appearing for the contesting
PP
of
Behera,
party. Sorry, PP Behera, learned counsel appearing for the contesting opposite party seeks at least 1 week time. Hello. So this court direct placing for to take appropriate instruction.
Yes, ma'am.
place the matter on next Thursday. Next Thursday.
In fact, your lordship had indicated all these things.
Observes in the event, there is no admission of the appeal. There admission jodi heijibo. Apangara trial court judgment manakare kon lekha hue? The documents, MO or the documents are to be written so long as appeal period is over. So, yara appeal period kete dini?
In fact, the trial court had given 4 months time.
90 din assuming. It's a order acquittal.
Yes.
Dharantu 90 din. So 90 din pore, you have no right to withhold such document.
Yes, I bought.
Your appeal may be lying. So therefore, advise the client appropriately. The service book acquittal is service book entry hei par natibo.
My increments, everything has been held up, my lord.
Kichi punya karithile tenu suffer karuchonti au kon kariba.
In fact,
we know how acquittals are being made.
In fact, your lordship has relied in order number 1 itself. On the last date, had relied on a judgment of Kerala High Court, where it has been categorically stated that it's only required if there is some forgery in the
Mr. Rai, there is rampant filing of writ appeal if I don't grant time.
No,
so therefore, why to enter into? I
Yes,
have made it clear.
Next week we'll get.
I have made my mind clear to the council.
Yes.
धैर्य टिए धरंतु एते दिन तो रहिलेनी आउ 7 दिन रो कोन होई जाउछि.
Item 4. Challenging the illegal action of the opposite party of 3 and 4, who threatening the petitioner to evict from his land, my lord. In this case, my lord,
demarcation notice which is under challenge.
In this case, OSS case is pending before the Law and Member Board. During pending of the OSS case, my lord, the OP number 3 is 4 issued demarcation notice and threatening the petitioner to evict from
That's a different issue. You are not challenging the demarcation order.
Till disposal of the OSS case, my lord, no coercive action may be taken.
No, he is challenging the notice for demarcation. Annexure 4.
Come to your prayer.
Page 9.
Your apprehension remain ungenuine. Now your apprehension is on the basis of a demarcation order. Okay. Demarcation order re kon eviction hoई jaye?
They are frequently threatening, my lord. Frequently came to the spot and threatening to evict.
They have to go to the civil court for eviction. And if at all the demarcation report helps them.
Same issue, OSS case is pending.
OSS case pending, that's a different issue. You may get a success there. But if your civil right is infringed, go to civil court. Go to civil court because there can't be a foundation of eviction on the basis of a demarcation report. It's not a report obtained on the basis of any court direction. Somebody applies, she gala mapo kale tar consequence mein se court ku jiba agya eta mo paper re asuchi mo jaga se anodhikruto bhavare achanti tenu tanko hata jausi gote court ku jibo eti police ki tahsildar jai apun uthei dei paribeni.
Regarding same issue, OSS case is pending.
Sorry. Achi OSS Act re interim protection ro provision achi?
Not till disposal of
Achi ki? When there is failure in a statute or no provision in a statute giving such relief, can Reed Court give a relief? Permitted to withdraw. Dismissal of the writ application as not entertainable at this stage doesn't amount to be depriving the petitioner to approach civil forum if any. Yes.
Item 5.
The petitioner challenged the order number annexure 2.
Pardon?
Annexure 2, the holder dropping the demarcation case on the ground that there has been measurement in case number 20.
It is a demarcation proceeding.
Demarcation proceeding.
Demarcation re kon hela?
Demarcation drop kar the there was a measurement in case number 7/13.
Pardon?
Case number 70/13, there was a measurement.
Ah.
So no need of demarcation.
Right, so therefore you obstruct this demarcation proceeding.
No. I'm saying that demarcation should be made. Because my lord, there is a suit for partition.
He is asking the parties to be present.
No. He has
Oh,
dropped
no
the proceeding.
need of further demarcation.
Yes, my lord.
Case is dropped.
And there is a suit for partition. The final decree was passed in 28 2022.
All right, take notice.
My lord.
Yeah.
So government, I will serve notice to.
Aye kaun?
Aye.
Your case has been dismissed. What is this IA? IA not press kar do. Yeah.
From 6. My lord, here an expression of interest was floated.
I am permanent. Only Tahaldar party, so I am permitted to serve copy on the government office. Only Tahaldar is the party, so I am permitted to serve the copy.
Pardon, Subuni.
Madam, only Tahaldar is the party, opposite party.
Mic agar ko.
This is also functioning.
Mic ta take close karantu apon pakho.
It is there.
Madam, only state and Tahaldar is the party, so I am permitted to serve copy on the state council.
Only state is the only party, but adjacent owners may be there.
Yes.
Tam pakho karchen na nahi.
Yes, they filed objection, thereafter it was dropped.
I am permitted to implement the party.
Sorry.
Implement the parties.
Lekha, there is no bringing of the parties likely to be affected. The monthly learned counsel appearing for the petitioner. 6 time to bring parties likely to be affected. Let appropriate application be filed. Bringing in party likely to be affected. Matter be placed after the application, if any, is filed. Yeah. Yes, what is this? Is it my assignment, Mr. Bose?
Yes, ma'am. Other matters, my lord, here an expression of interest was floated. Expression of interest was floated.
Yeah.
In expression of interest, I expressed my interest. Then the provisions in the expression of interest said the MOU has to be signed. I sent my MOU to the opposite party, number 1. 2, they did not sign the MOU. Then they issue a show, and without signing the MOU, they enter into a contract with government. They try to enter into a contract.
So it's a contract matter.
No, madam. They want.
Say, my lords. Madam,
please.
Just 1 minute, 1 minute.
I am only submitting that I am appearing for the respondent number 2, madam.
That's right.
She has
OP
appeared.
number 2
Last
and
order, your
It will
lordship.
be taken care of. It will be taken care of.
Last order, your lordship may see that appeared so moto. My lord, they issued me a show cause notice that why you will not be blacklisted. I filed my show cause.
No, Mr. Bose, where is the assignment of this matter to me?
Blacklisting matter. It is not assigned to any bench except other matters. It will go to before your lordship.
No, blacklisting as an outcome of a tender or not?
No, it's not.
Or malfunctioning in a tender process.
My lord, it is an expression of interest to participate in a tender. Tender was not there. So it was only an expression of interest. I give an offer to X.
Right.
The X.
Where is that blacklisting order?
Yes, blacklisting order. Last annexure, my lord. That is annexure 12.
No, annexure 12, it is only asking you to have your submission.
No, my lord, they have blacklisted me. They rejected and blacklisted.
Where is that? 210.
210.
210. Please read that paragraph.
Actually, Messrs. Link Computer is hereby
Please be on mic. Please be on mic.
My lord, accordingly, the Printlink Computer and Communications Private Limited is hereby banned from participating in future new works, tender of and on any procurement process undertaken by TCI.
Right, so therefore, there is final blacklisting.
Yes, blacklisting. My lord, here expression of interest was floated.
All right. Just why are you in hurry? Yes, madam, you are appearing for OP number 1.
2, my lords.
Number 1.
My lords, I have filed my counter, my lords. detailed counter, my lords, stating, my lords, first of all, there are two submissions, my lords. My lords, as per,
Just I'm making it clear. This is
Yes,
for
my lords.
press admission.
yes, my lords.
So this is a serious issue. I am to
Yes, my lords.
examine.
Yes, my lords.
Therefore, I am issuing notice. You file, you bring your counter if
I have already filed, my lords.
you have already filed.
Yes, my lords.
But pre-admission. Pre-admission,
Pre-admission.
counter has not come on
No.
board. So therefore, if you have filed, it
Yes,
will
my
come on record
Very well, my lords.
and the matter will be heard finally.
Very well, my lords.
That's all.
Very well, my lords.
If-
Now what are doing, they are doing? They blacklisted me.
Don't expect any interim.
No,
order.
I'm not expecting interim
Yes.
order. I know, I'm aware of
Yes,
blacklisting.
it is final.
My lord, what they are doing, they have blacklisted me from their company.
Yes.
Now they are doing what? They have put it in the website and they are writing to others.
That will be there. It's a
Writing
automatic.
to others that you
It's a
blacklist them.
automatic fallout,
But-
Mr. Bose, unless you get clear from
But
this
my
order.
entire contract with others.
Above
is going
contrary.
away. So I only
Can
pray,
there be,
madam, I
massive
only
injunction?
pray, the blacklisting may be confined to the OP number 2 only.
No, that after hearing only.
My lord, then I will, no, I cannot participate
No,
in
no,
any
then-
other tender.
Then where is that challenge? That in the meantime, you have been
lord,
blacklisted for all.
My lords, may I say?
Just
Yes.
1 minute.
They are, I have filed the IA, my lord.
IA know that unless you bring that incorporated in the REIT application, I can't hear IA independently.
My lord, that is a development after blacklisting.
So I'm bring amendment. Bring amendment. That may be a challenge by you.
I'll
There
amend-
can't be any interim direction bereft of the pleadings or the claim in the REIT application.
No, my lord, here what has happened?
And on your own, you say it's a subsequent development. So bring
Yes.
amendment.
Yes, it is.
So after amendment admission kariba na batan admission kariba? That's a question. Sorry, I'm speaking in Oriya. Normally it comes out.
I followed, my lords. I
But
followed.
my problem is, I will stand nowhere. My lord, they are writing to others
Mr.
that you
Bose,
blacklist them.
Mr. Bose, who prevents you from challenging?
Amendment.
So I am adjourning the matter for amendment. Let us not issue notice now.
Yes.
So that your interim application
I
can.
do not want notice against OP number 3, man.
No, I am not issuing notice now. Because if you place the interim application now without amendment, the interim application is wholly not maintainable.
I'll amend it, man.
So therefore, don't run the risk.
I will amend it. I got the point, man.
REIT application is
Your
accompanied
lordship may put it to next Thursday. I'll amend in the
with an
meantime and
interim
soft copy.
application.
My lords, I would need some time, my lords. Next Thursday will not be possible for me, my lords.
My lord, I am unable to participate
lords-
in any tender.
Okay.
My lords, he's making
Give
an
a
incorrect
consent date,
statement, my lords.
Friday,
It's a
next
false
Friday,
statement which my learned friend
Next
is making.
Friday.
My lord, I can demonstrate from their own
Oh,
letters.
why there is collusion on this issue?
Yes.
We have to fix a date, give a consent date.
My lords,
Friday, next Friday, or Monday next.
my lords, give me a
He has
moment.
urgency. Therefore,
My lords, 27th or 28th.
that will be far away. He is in urgent interim application.
My lords, 24th, my lords.
24th.
Monday.
also.
It's a Monday, my lords, 24th.
My lord, why not on Thursday? My lord, 24th Monday is your lordship's most heaviest day.
Let it be on 20th, madam.
28th, my lords.
20th. 20.
20th, my lords, I have.
You are busy counsel, but he
No.
is in hurry
No, my.
in getting an interim order.
19.
Come to that week, 17th to 21st. Today,
Well,
we are
so only-
already on 13th.
Yes, my lords, only
So-
24th I am
Oh,
praying, my lords.
Mr. Bose, you are asking for 1 week time for
At
amendment.
24th, my
I
lords.
can
only.
file tomorrow, my lord. Amendment I'll file tomorrow.
I'm only praying for Monday, my lords, 24th, my lords. 24th, it's,
So let it come on 24th.
I'm so grateful, my lords.
Yes, there's the interim application accompanied with the REIT application with completely new pleadings. On his own, Sri Bose submits. This is because of certain development taking place after the filing of the REIT application. For the opinion of this court, the issue involving IA cannot be taken into task unless such facts brought by way of amendment to the REIT application. Sri Bose Learned Counsel seeks at least 3 working days for bringing the amendment application. There is already appearance by Madam, you are
Rashmi Malhotra, my lords.
Malhotra,
Yes,
Miss Malhotra.
Yes, my lords.
Okay. There is already appearance on behalf of, you are appearing for OP number?
OP number 2, my lords.
2.
Yes, my lords.
OP number 2, contesting opposite party through Messrs. Rashmi Malhotra and associates. Copy you have already served?
Yes.
Since they have appeared.
I have also served, my lords, the copy
Yes,
of counter.
counter they have served.
Okay, copy of read petition already served, stated to have been served.
But my lords, may I say so, my lords, if my learned friend is amending the
Counsel.
petition.
Rashmi Malhotra also makes a statement that there has been already filing of a counter affidavit. This court records filing, the counter affidavit has been filed pre-admission stage. If any counter affidavit is already filed, registry directed to assemble the same in the brief on the next listing of the matter on 24th. 24th.
I am so grateful, my lords. My only humble submission before my lords is if my learned friend is amending to some extent the petition, so I may be permitted to reply to that also, my lords, by filing reply.
Absolutely, once amendment is allowed.
Very well.
Amendment application, copy of amendment application.
serve
already
Monday.
Filed.
Monday I'll serve.
Copy, 3 working days I am giving you.
Yes, madam.
Copy of the same may also be served on the counsel for opposite party number 2. You have a counsel at Cuttack?
Yes, my lords.
Okay,
Mr. Ashok
right.
Mishra is-
Right, you keep contact with him. Okay, further counter affidavit, if any, on the basis of, to the amendment application. We also filed by the next date. Yes, place
I'm
the
sorry.
matter on 24th.
I'm
Sir,
so
appearance
grateful.
of Union of India में kindly move.
Union of India का नाम लिख दियो.
Obliged.
I'm so grateful, my lords. Obliged.
Thank you. Yes. Item 7.
Item 7. May please, your lordship. In the case matter, the
Receiving land revenue.
lordship, Jalakara Maguchanti, non-irrigated land to Maguchanti, annexure 1 is the
Land
report,
revenue or water revenue?
water revenue
Water revenue.
again. But they are not receiving the land
You
revenue.
have an application pending by Daneshwar 2 probably.
2 is not, 2 is the report also. Page 18.
1 is the application.
Yes, page 18 is the application, your lordship.
18 is the application, 2 is the report.
2 is the report.
What is the outcome?
Nothing. They are not issuing the demand notice. They are not accepting
All
the
that
revenue.
I'm giving a direction for a lawful outcome. Question involve following prayer. Hello. At the same time, this court find petitioner as a pending application by Daneshwar. Running page 18. There is even a report of the revenue inspector to the request by Daneshwar by page 18, available at page 19. On the submission of counsel for the petitioner, there has been no final outcome to his request, to the request of the petitioner at page 18 of the brief. Considering this is a pending case, this court disposes the writ application directing Tahsildar Simulia.
Simulia, lordship.
Now Simulia election kahingi Simulia kothi asibo na eta Simulia Markona lekha hochi mane Simulia
Simulia. SIMULIA.
Bhadrak.
No, district of Baleshwar.
To give a lawful disposal to the request of the petitioner at page 18, while also taking into consideration the report, if any, by page 19. By working it out within a period of 2.5 months on the date of communication of the order. We copy of order to state council. Yes.
What happened, your lordship? They are not accepting the revenue only.
ठीक अछि ननौचंदी ताको खुशी
प्रॉब्लम होछि कि रेवेन्यू न नै कि काथरा गोटे कहउछन एति क्लियर न कले आमे तमर किछि न
केते टंका होबो 10 टका के 15 टका होतबो
सेटा भी नउनांती से कहउछ जळकर सब बर्तन गोटे डिमांड पत्रनी
बहुत पैसा से बांटीवार लागि छथि वर्तमान अरे रखन तो पैसा
एटा बड सिचुएशन, your lordship, both are
My lord,
Yes,
I-
yes, item E.
my lord, it is a covered matter. I have enclosed annexure 4 orders of this honorable court. Also, directions may be issued to ASO to accept. the
Miscase
mistake.
accept करना
My lord,
They are not accepting the miscase.
no, they are not accepting the mistake.
So it is covered by page 29.
Yeah.
All right, same order. Yeah.
Item 9.
Item 9, my lord, I am challenging the dismissal order passed by the OSS settlement officer on a mutation
Appeal is
of.
already registered. You yourself say appeal number 387 of 16.
Is also dismissed the
disposal ଚାହୁଁଛନ୍ତି appeal.
ନା dismiss ହେଇଛି ବୋଲି କହୁଛନ୍ତି।
dismissed.
Huh?
Dismiss ହେଇଛି ସେଇଟା challenge court.
Come to your prayer.
Yes, my lord.
Oh, restoring.
ଆଜ୍ଞା।
Restoring High Court କାଇଁ mandamus ଦବ? Have you filed any application for restoration?
Yes, my lord.
Where is
Annexure
that?
5.
Annexure
Annexure 5.
5.
କେତେ page କେତେ?
No, 5
Page
is a
32.
communication of
Annexure
the
6.
additional
6, my
secretary.
lord. 32 page.
Page
Running page
32.
32.
ଏ ଜିନିଷ କରୁନାହାନ୍ତି। But you are
No, this is there something different. Your prayer is to restore the appeal.
And
Annexure 6 is prayer for correction of the mistake made by settlement officer.
no ଏଠି
Yes,
ଆପଣ
ma'am.
ଟିକେ ଦେଖନ୍ତୁ page 26 ରେ 16/5/2018 this case is put up today, appellant is absent.
That is in appeal.
Yes.
So
Appellant
therefore,
in appeal.
Appellant will look.
he may have a case for restoration.
Yes.
But look to his prayer. Prayer is also for
My
restoration.
prayer is the
So
mutation
while
appeal
he
case
will file
re
for restoration,
Again.
he may challenge the appeal order.
Appeal.
Then we may, if we find that's a illegal order, we may.
This has been dismissed for default.
but
This
the
appeal was dismissed for
also
default.
present.
Prayer ଆପଣଙ୍କର ଠିକ ହଉନି.
Previously, he is repeatedly present the
There
case.
is no coherence. Your prayer appears to be restoration of the appeal for a lawful disposal.
Yes, ma'am.
Your page answer, this page 32 document is a different request.
For
This
recalling the.
petition appears to be having multiple requests.
Yes, ma'am.
କେତେ ବର୍ଷ ହେଲା ଓକିଲାତି?
Within 1 year. 1 year.
1 year. ଆପଣ ନିଜେ ଫାଇଲ କରିଛନ୍ତି ଏଟାକୁ?
Yes, ma'am.
Please consult with somebody. ମୁଁ ଆର୍ଜନ କରିଦଉଛି ଦେଖନ୍ତୁ କଣ କରିବେ ଆପଣ।
ସେଇଟା past ହେଇଥିଲା
But it
mutation
was something else. It was prayer for correction of mistake made by the settlement officials.
Yes,
High
that
Court
is
note.
a different
That is
issue.
not a prayer for restoring the appeal.
That is a different issue.
Yes, he used to make an application for restoration.
He is to
Annexure
make up
6,
his
my
mind
lord.
where to proceed.
Annexure 6, my lord, it is a prayer there
Sorry,
to
sorry,
recalling
your
the.
prayer is not in consonance with page 32 document. Page 32 is a different prayer. Prayer here is a different issue.
Only
Prayer
my
here
lord,
is restoring the appeal.
See, actually ସେଠି ଯାଇକି ଗୋଟେ restoration application ଟା ଦେବା କଥା।
permit to
ତା
restore
ସହିତ
this
ବସି କଥାବାର୍ତ୍ତା
application.
ହୁଅନ୍ତୁ କଣ କରାଯିବ।
Permit to restore
ହଁ,
this
ତାଙ୍କୁ
application
ବୁଝେଇ
may
ଦିଅନ୍ତୁ।
direct.
ହେଲା। I am placing it on Monday again. Come with appropriate application. You are a young counsel, I am not dismissing. Yes.
It is challenging the action of the additional Tahsildar. It's covered by your lordship's order. I have given the order.
ଦିଅନ୍ତୁ। Yes, all right.
Obliged.
Item 11.
Nobody is present to pursue the matter. Requisition stand dismissed for non-prosecution.
Non-prosecution, my lord. Dismissed for
non-prosecution.
Item 12.
Please, lordships, consideration of the annexure 5 as per the section 111 of the mutation manual, the matter of fact is that I am the purchaser.
All right. Annexure 3 is pending.
Annexure 3 is the correction of the ROI regarding the consideration of the Annexure 5. As because Your Lordship, the guideline cover the Harihara Mahapatra case. The matter of fact is that, Your Lordships, I am the purchaser in 2007. The person who have to sell to me, he have to previously purchase in 1987. Thereafter, he filed a RC case.
Correction of record of right.
No, Your Lordship, the question, the matter is further after purchasing myself. From the mutation khata. I may kindly.
1 minute.
Yeah, let's say after I am purchased in 2007, the purchase from the mutation khata. That mutation khata recorded in the name of the son Padi Sahu, some Padi Sahu, who is as per who is very clearly mentioned in the land register.
He is the vendor.
The land register is the
He is the vendor.
He is the vendor.
He is the vendor.
Vendor.
Then now, therefore, you want correction of the record of
Yes,
right.
Lords.
In terms of the sale deed.
Yes, Lords.
So give a lawful disposal to
No,
Annexure
his prayer is that consider my representation vide Annexure 3.
Regarding
to
Annexure 3 lekhuchandi.
Annexure 3 to no.
Annexure 3 na. Annexure 3.
Dekhile.
So Annexure 3 ta allow kin kar daba hame.
Annexure running page 24. Running page 24.
What is Annexure 3?
Annexure 3
Annexure 3 page kete?
Running 24. 24.
एठी प्रेयर करूछुंदी जे Annexure 3 टा रिप्रेजेंटेशन का
Annexure 5
फाइल होची
Annexure 5
Annexure 3 टा को allow कर दवा
ना Annexure 5 टा मु आगे Annexure 3 टा जो जिंसटा
खुची काई प्रेयर लिखुचुंदी
आगे
एटा प्रॉपर्ली करना Annexure 5 टा कंसीडर हो
5 कंसीडर हो ओके
एटा आपण
Annexure 3 टा allow कर दियो
ना
Annexure 5 को allow कर दियो लिख दिलनी एठी ये कितने allow लेते आप
correction I beg to pardon, just there is a mistake allow करे पे लिखी नहीं
allow लिखिन बा
ना consideration
पढ़िले page 6 रे read the honorable court kindly allow my representation Annexure 5
हाँ representation मैं kindly consider भूल रहे अगेन typographical ही
typographical error or wrong application of mind काई टाइपिस्ट को दोष दउचंदी आपण तो जा लिखि देबे से बाडेला
ना से बेले बेले आज्ञा
निज दोष मानन्तु किछि एतरे किछि भूल नाही मानि नवाटा ही विज्ञतार परिचय
आज्ञा मान
there is wrong prayer. Counsel for the petitioner while admitting that the read petition simply involved a direction for consideration of the representation dated 12/5/23 appearing at Annexure 5 and limits his prayer in the writ application to this extent only. Okay, brief makes it clear. In the consideration of representation at Annexure 5, petitioner has an intention for correction in the record of right Annexure 3. This court, without expression of any opinion, disposing the writ application, direct the Tahsildar so and so for giving a lawful disposal to the request of the petitioner involving correction of record of right, involving land particular so and so by Annexure 5. Necessary action dependent on the at least undertaking the exercise within 2 months, dependent on the outcome through Annexure 5, appropriate action involving Annexure 3 may also be undertaken within reasonable time. Prayer prayer actually ठीक रहिबा दरकार. Prayer टा प्रारंभ कर देबे.
Item 13.
May I please, Your Lordship?
13.
My Lord, for a moment, kindly turn to page 55 of the brief, my Lord. Here the counsel for the OP number 1, I think. Here the counsel for the OP number 1 in page 55, the impugn order. I think Your Lordship is concerned.
At our court ko jibo. All right, this court has difficulty in hearing the matter. So for the involvement of counsel, special counsel in the proceeding in court. Place the matter before Honorable Chief Justice. Rest is to place the matter before Honorable Chief Justice for assigning the matter to some other court.
For placement.
Item 14.
Please, your Lordship, my lord, I am at BC Puri, my lord. Here I have challenged the improved order passed by the Chief Administrator, OP number 2.
Here, Jagannath Temple matter I am not hearing. This court is not hearing matters of Jagannath Temple. Place the matter before some other court. Yes, rest of the cases after recess.
Balance.
Same khata and plot, your lordships have decided in Annexure 6. I have submitted a copy with the court master, my lords. Annexure 6 is covered, my lord. Say khata, say
Yes,
plot.
it is covered.
Yes.
There is no dispute in bar that this matter is covered by. A judgment of this court already rendered in WPC number so and so dated so and so. Order in this case runs as follows.
Obliged.
Item 16.
May I please, your lordship? My lord, in this writ application, the petitioner is paying for a direction to the Tahsildar Yamuna for settlement of Bhutan land. Your lordship already disposed of similar matter.
Pardon?
Your lordship already disposed of similar matter, my lord. Order.
Similar matter?
Again.
Oh, Bhutan land. All right.
Representation is not maintainable. He has given the representation before the Tahsildar.
Bhutan land ame kon order karche?
Taking into consideration of Annexure 2 and 3 also.
Achhi ta aguru direction nahi.
It's an appealable order.
So I don't say you will allow or reject. Okay, give a lawful disposal. What is there? Any proper proceeding has to be there to be adjudicated. He can pass that order so that he will follow that.
Item 17.
Yes, item 17, the property was leased out in favor of my lord's original lessee under WL case. Thereafter, my lord's resumption case was initiated, it was dropped. I purchased the property, my lords. Now, my lords, the settlement authority recorded the property in the name of Abad Jogya Anabadi Khata. Against that,
My lord cannot hear. Kindly see page 47.
Page 47. Yes. Which order? Order date?
Order dated 21/3/22.
Yes.
Stand-
Read, please read.
The case.
Oh, all right, all right. I
Yes.
can't hear this. This is for the standing counsel appearing in the lower court proceeding. And this court
Oh,
can't hear this matter. The matter will be listed before any other bench, but after obtaining permission from Honorable Chief Justice. Author टा भी सेया की?
same.
सेया? Author भी जीवा.
Item 19.
May I please, Your Lord? My Lord, the petitioner is the owner of.
Mr. Lenka,
My
what is the position of construction?
construction, my Lord, they have not started. I have also.
So I am directing if it is not commenced, then let there be a lawful decision.
Yes. पूरा उटा close कर दो जो से घर भी बाहरी परियो.
Oh, I will not take decision now.
No, that
ସିଏ
is-
ତାଙ୍କର ବୁଝିବେ ଦେଖିବେ local issues.
हाँ, तो
ହେଇଥିଲା ଏଇଭଳି ଗୋଟେ ହେଇଥିଲା କଳିଙ୍ଗ ହସ୍ପିଟାଲ ପାଖରେ ଡାକ୍ତର କରିଦେଇଥିଲେ ପାଇଖାନା, that got resolved. Yes, like a petition involved following prayer. On the self-same issue, it appears annexure 6 is pending before sub-collector Kendrapada, OP number and so. Okay, for considering it a pending matter before competent authority, this court declined to entertain the writ application, however, direct OP number so and so to take a
Three.
lawful decision on the same. Also involving the petitioner, since likely to be affected by any adverse order passed against him on such issue. Allow with this, the action as appropriate be, decision as appropriate be taken within a period of 1.5 months. This order is, however, provided there is no commencement of the construction involved herein. 3 copy of order to state
no
council.
further construction if construction not started, Your Lordship. No further construction if not.
Yes, if there is no construction commenced, there shall be no construction till outcome. Yes.
Item 20.
This writ application arises at a proceeding under the Survey and Settlement Act, my lord. Your lordship will kindly turn to page 37. 37. In a writ appeal, 37, your lordship will kindly see, there was a direction by the division bench.
Yes.
My lord, first paragraph or last. And so you direct the settlement of the major settlement Cuttack for to prepare the record order in favor of the appellant as executed pursuant on the production of the copy of the order.
Okay, there is a direction for preparation.
Preparation, my
Right?
lord.
Then
Thereafter, my lord, the settlement officer, my lord, transferred the brief to Assistant Sub-Collector Bhubaneswar. And under Annexure 11, my lord, what is the scope to reject my claim, my lord?
First, let us examine then. This is an order you are aggrieved.
Aggrieved hoche Annexure
So
11.
let us issue notice.
Annexure 11,
Yes, 11 you are aggrieved. Annexure 11 you are aggrieved.
my lord.
Yes, all right, take notice then let us.
May I pray one thing, my lord? In so many cases, your lordship directing for preparation of a record of rights.
Record of right, but there is a rejection order already.
No, no, ସେଇଟା କହୁଛନ୍ତି ଏଟା covered ହଉଛି ନା ଆପଣଙ୍କ order ରେ?
Okay, you are aggrieved by this order or not?
Ah.
Page 39.
ନାଇଁ ନାଇଁ ସେଇଟାରେ
unless
your
that
lordship,
goes,
ନାଇଁ ନାଇଁ your lordship while quashing that ସେଇ ଯୋଉ କଣ ତାଙ୍କ ନାଁଟା ଯୋଉ chief justice ଙ୍କ court ରେ ହେଲା
Lordship,
Narottama.
do you agree for that?
Lordship, my learned senior is referring to Narottama Ratha case, Your Lordship.
Yes, yes.
In these two cases also, there has been a previous revisional order under the OGLS Act, Your Lordship. That I'm not disputing. So that is there. Factually, it is similar to that case itself, Your Lordship.
Okay, all right, then. More order time, Chandi.
ଆଜ୍ଞା
All right. All right, after having
ଖାଲି Annexure 11 ଟା quash ହବ
State Council, ହେଲା. Order runs as follows. All right, both the matters sent.
ହଁ ସେଟା Annexure 11 ଏଟା ସେଟା Annexure 9
ଦେଖିଦବ କୋଉଟାରେ କୋଉଟା ଅଛି ହେଲା।
Secondary annexure 9.
Item 21.
May I please, your lordship? Annexure 3 is pending before the Tahsildar to release the balance outstanding dues, though the work already completed by the.
All right, prayer court kar di on self-same issue. Application at annexure 3 appears to be pending before Tahsildar Buguda OP number so and so. Without expression of any opinion on the merit involving the claim, this court simply directs the writ application directing Tahsildar Buguda OP number so and so for giving a lawful disposal to the request by annexure 3 by completing entire exercise within a period of 2 months from the date of communication. Free copy of order be handed over to State Council.
Obliged.
Item 22.
Item 22, my lord, said election dispute. Whereas the petitioner is the defeating candidate for the post of Sarpanch, seat of Sarpanch, my lords. Whereas kind of a glance to the petition filed, my lords, by the annexure 1.
This is what is the application considered?
Application says, my lords, the evidence is over from both the sides. Now I've categorically stated that booth number 9, this much of votes you have taken it from my account and added it to the elected candidates. We have given the detailed particulars. In spite of that is what we requested, because the contesting opposite part number 3, the opposite part number 3 who was the counting officer, he didn't appear, didn't file any objection on petition. I filed a petition to call for those records and documents and ballot papers and the result sheet and all these things as is required for just adjudication.
You have sufficient pleading in the election.
That is exactly my I want to point.
Petition, not
Yes,
in
yes.
the petition present.
No. This original petition. They have
Petition, you have such pleading.
yes, ma'am. Categorical pleading in para 6, para 7, para 8. Man, kind of para movement para 8 page 19. Page 19.
Yes.
That most unfortunate situation happened while ballot booth number 19 was counted. It was around 9 a.m. At 1/3/2022. The petitioner witnessed.
Then your evidence is also.
Evidence.
standing.
I've given this evidence of PW2, who is an independent balance person who was available.
What happened? The application has been
Petition was
rejected.
rejected. So that rejection of order.
You are the election petitioner.
No, I am the election petitioner. My petition to call for those documents.
You are the election petitioner.
I am the election petitioner, defeating candidate.
Issue notice on the question of admission. Requisites accordingly karibo, fixing short returnable date. Matter be placed immediately after appearance of contesting opposite parties. In the meantime, miscase notice as above, one set. In the meantime, there shall be a stay of further proceeding in election miscase 13 of 22. Yeah.
Item 23.
May I please, Madam? Now, admission of SRP case number, my lord, 139 to 200 and early disposal of the same by opposite.
Press admission. Early disposal, epe direction nahi.
Kalu thau word, my lord, early disposal. Early disposal ପାଇଁ ଗୋଟେ ଆପଣ
admission ତ ହେଇନି ଏପର୍ଯ୍ୟନ୍ତ pleading complete ହେଇନି early disposal target କେମିତି କରିବା ଆମେ
usual order ଆପଣ ଯେମିତି ଦିଅନ୍ତି.
The right to request for early disposal of the matter is kept reserved. It may be open to the petitioner to have renew his prayer on the targeting of the matter at appropriate stage. Writ petition simply disposed of directing early action for fresh admission of the matter. At least within 7 days of the production of copy of the order.
Item 24.
My lord, 24, petitioners are the cultivators. They are the cultivators and they are also cultivating their respective lands, which are recorded in their favor.
Subuni.
Ebe subila.
ଟିକେ ଆପଣ mic ଟାକୁ ଆପଣଙ୍କ ଆଡକୁ ଟାଣନ୍ତୁ. These are all applications pending.
My lord, pending, but they are not taking any step. They are lifting the mud and sand from their
Okay, then what do you propose? By issuing notice, there may be some development.
Your lordship might direct them to take instruction in the matter. What step they have taken pursuant to our representation. Fixing a next week, your lordship may keep it to next week. Because this is the
Two extra
cultivating
copies we
season.
served on State Council.
Lordship, may I only point out one aspect, Your Lordship?
Yes.
In fact, the allegation by the petitioners is that they're taking the soil away from their land, Your Lordship. So that will come under illustration A of section 378 of the IPC, Your Lordship. So therefore, let them file an FIR before the police so that.
My lord, I have approached the
No,
police.
That is
Annexure
also
two.
one of the issue.
Annexure 2, I have approached.
Okay, there is, but what is the administrative action then?
Yes.
That will be criminal action against the persons who are stealing.
My lord, stealing,
So that is the option open to the parties. But then will you secure the property or not?
I'll take instruction.
Administrative action. Therefore, take instruction as to what steps they are taking.
Lordship.
Even after giving the complaint by Annexure 1, 2, and 3.
2 has been addressed to the police. 2 has been addressed to the police. No step taken. 1 to Tahsildar, 1 to collector.
Gote ଅଛି ଭାରପ୍ରାପ୍ତ ଅଧିକାରୀ ନର୍ଲା କଳାହାଣ୍ଡି ବି ଅଛି Annexure 3.
Annexure 2.
So could have registered.
No.
So maybe there is connivance. ଏଗୁଡା ହଉଛି ସବୁ ବିଭିନ୍ନ ଜାଗାରୁ ମାଟି ଗୁଡା ଉଠେଇ ନେଇ ପଳଉଛନ୍ତି ବିକି ଦେଇ ପଇସା ନେଇ ଯାଉଛନ୍ତି. ତାପରେ these people will be or administration will be running before the people. କିଛି trace ପାଇବେନି.
They belong to the.
So take instruction, some administrative action, immediate administrative action is necessary. No purpose in following criminal suits.
Yes.
Okay. May land somebody in jail, but how the benefit comes back?
This is the cultivating season also.
Extra copies, 2 extra copies be served on State Council, who is directed to take instruction as to any course of action undertaken pursuant to complaint lodged by Annexure 1, 2, and 3 by the competent authorities by the next date. Place the matter 3 weeks after date.
Early date, I would call. Early date, because cultivating.
3 weeks after.
3 weeks and 2 weeks करो.
Again, ଶୁଣନ୍ତୁ ଆପଣ ତାଙ୍କୁ ସମୟ ଦିଅନ୍ତୁ so that ଯଦି କିଛି lawful action ନବାର ଥିବ ସେ ନେଇଯିବେ ଏ ଭିତରେ. So ଆମେ 1 week କହିବା ସେ କହିବେ ଆଜ୍ଞା ଆସି ନାହିଁ. So therefore give them breathing time.
Oblige.
Yes, next.
Item 25.
Mr. Mishra, in the meantime, instruct your clients to see that there is protection of the lands.
Lordship.
That can be at least ensured.
My lord.
May I please? My lords, I checked up, your lordships had said first lady lawyer, my lords. That is
25.
No, again, upon koithale first lady lawyer, you had first lady lawyer.
Say list kahin?
Say Mrs. I mean Hazra, Miss Hazra.
No, Hazra mu janichi, mu koithili, mu se na janichi. Mu ta enrollment number. And mu magithili Supreme Court re se succeed kale se case ro number tiye diyantu.
सेटा बोधे मिलिबा एथि women's college रे गोटे magazine अछि मु let me find out.
ऐसे Supreme Court judgment टा अछि कि सेते
सेटा देखि दिए कारण पाइथिली सेइथिरे
दियंतु हमर अछि टाइम अछि.
हाय ना एथरे हम ये रे भी मानले एनी
मिलुनी तो ए पर्यंत
मिलुनी ना देख
मिलुनी.
सुधांशु बाला हाजरा बोली कि मु जानि छी एवं सेटा.
Please. All right, if you get it, inform. I want to know that case because that case benefited this Hazra and another Guha probably Allahabad.
One from Bombay, some
Allahabad.
Sorabji was the first advocate.
Sorry, Sorabji. Right.
She canvassed.
Sorabji and Hazra both got benefited by that.
Yes.
There was a statutory amendment to the Practicing Act.
Hazra is the first lady lawyer.
He sabu agya itihas sabu jana kevol se trace ta pauni, judgment ta pauni. How enrollment number dita darkar se first enrollment number.
Se to Calcutta Bar Council thi hota most.
Apon ete bada bar council member sabu apon collect kar peribeni. Your secretary can contact their counterpart and this is necessary. This
is also a part of our history.
Yes.
Well, here the petitioner challenges the preliminary inquiry report at Annexure 5, which is in contravention of Section 20, subclause 2, as well as Section 20, subclause 5 of the Odisha Lokayukt Act, 2014.
No, where is the scope for taking out a P report?
My lords, there is a preliminary inquiry. Your lordships may kindly see section 20, my lords. 20 re goda preliminary inquiry pai the Lokayukt can ask their authorities to investigate. But 22 provides during the preliminary inquiry referred to in subsection 1, the inquiry wing or any agency shall conduct a preliminary inquiry on the basis of material, information and documents collected, seek the comments on the allegations made in the complaint from the public servant and competent authority, and after obtaining the comments of the concerned public servant and competent authority, submit within 60 days from the date of receipt of the reference or report to the Lokayukt.
So a proceeding is pending. Report has been called for. Preliminary report has been submitted.
Preliminary inquiry report has been submitted. Which is known as my humble submission before your lordship is, my lords, there was a direction by the Honorable Lokayukt, Annexure 4 at page 24, that comply with section 22. I had taken, my lords, they called me for a date. I had taken only one date. Thereafter, they never called.
Before any order is passed, you will be definitely provided with opportunity to contest this.
That is exactly what has not happened. That is exactly my case. That 22, the Lokayukt also, Honorable Lokayukt also says you comply with section 22. Your lordship may take up Annexure 4 at running page 24.
Page
24.
24, yes.
Having considered, third paragraph. Lordship gets it?
Yes,
having considered the allegations of misappropriation of huge amount of government fund by the respondents and the separate replies filed by the respondents, we in exercise of our powers conferred under section 21 of the Odisha Lokayukt Act 2014 deem it proper to direct the Director Vigilance Odisha Director to conduct a preliminary inquiry which is in pursuance of section 20 subclause 1 for ascertaining whether there exists a prima facie case.
Therefore, now for your submission, section 20 bracket 2 has not been complied.
Again, they say, my lord, just needless to mention that the Director Vigilance shall ensure compliance of the provisions of section 22 of the Act.
Right.
This is the first point. They called me for a day. I sought for an adjournment. I said, because these are numerous documents that they were giving, I said, I will find out what are the documents. Please supply it to me. Thereafter, they never called me, nothing, my lord. They gave the preliminary inquiry.
So your case is there is no compliance of the provision at section 20 bracket 2.
Subclause 2. Then,
so that ground you can very well take there that this is not a null and void report.
My lords,
it is not in terms of section 2 compliance.
My lords, that is my first point. Second point is.
So you raise that. I'll direct before taking any action on the P. The first you will decide whether P is acceptable or not.
Whether the preliminary inquiry report is acceptable or not. They will have to decide that. And 25. My lords, 25, why I say, my lords, the preliminary inquiry report has been given after 11 months. Now, 20 subclause 5.
No, Mr. Kanungo, my point is,
yes,
you have all the option to raise, agitate all these grounds before the Lokayukt. Why are you arguing before High Court?
No, if your lordship directs them to.
If after that exercise the Lokayukt still commits any mistake, then High Court jurisdiction comes.
My lords, your lordships may direct the Honorable Lokayukt to consider my preliminary objections first, that there has been violation of section 22.
Submission of Sri Kanungo along with
Dipankar Acharya.
Read petition, main thrust in bringing the read petition appears to be, even though there has been submission of a preliminary inquiry report, page 30.
25 is the preliminary inquiry report 25.
By Annexure 5.
Yes.
But
Page
the preliminary inquiry report is not in terms of clear direction of the Lokayukt dated 13/5/22. There is serious allegation in spite of Lokayukt directing submission of the PE report, ensuring compliance of provision at section 22. Taking down to the pleadings herein, there is serious allegation that there has been in fact no opportunity to the petitioner herein before submitting the preliminary inquiry report. Okay, for the opinion of this court, looking to the stage of the matter,
My lords, another point is there has been violation of 20 subclause 5. My lords, 20 subclause 5 provides
20 subclause 5.
Yes, my lords. I'm reading out. Every preliminary enquiry referred to in subsection 1 shall be completed within a period of 90 days and shall be completed and for reasons to be
So
recorded.
this is 20 bracket 5.
20 bracket 5.
There is also serious allegation of the preliminary inquiry report being violative of provision at section 20 bracket 5 of the Odisha Lokayuta Act. For the opinion of this court, since the matter is in adjudication of the Lokayuta, further, the Lokayuta is yet to take a decision on acceptability of the preliminary inquiry report. Considering petitioner has a valid ground to object acceptance of such report, without expressing any opinion on the same at this stage, this court observes. This court, considering petitioner is already in possession of the preliminary inquiry report, shall have the opportunity of objection in the acceptance of such report in view of the violation of the provisions taken note herein above.
Deeply obliged.
In the process, this court permit the petitioner herein to have his objection, taking all such grounds taken herein, objecting by way of objection to the preliminary inquiry report on the next date of posting. Okay, in such event, the Lokayuta shall do well in first considering the objection of the petitioner before taking any decision on the acceptability or non-acceptability of the preliminary inquiry report. With this observation, the proceeding stands closed.
May I pray? I get a certified copy, urgent certified copy. Kali achi to.
Kali ki?
Kali ki achi to. Urgent
out ketole koribi mo.
Otherwise, I'll give an affidavit.
Considering the case is posted to tomorrow,
Yes.
ମୁଁ 7 दिन ଦେଇ ଦଉଛି ଆପଣଙ୍କୁ. I am granting you 7 days for filing objection. ସେ ଯୋଉଟା କହିଲିନି on the next date of posting ସେଦିନ ସେଟା ଲେଖିତ at least within 7 days of the order. Again, since the case is posted to tomorrow, on an application being filed seeking adjournment for 10 days, the Lokayuta shall do well in adjourning the matter for 10 days.
Deeply obliged. Sir, gotte mistake achi. Gotte amoku sir ye asla. ठीक अच्छे.
Item 26.
Deeply.
My lord, item 26. Item 26.
26 कौन है? First contempt की?
No, my lord. In fact, Mr. Ponda is out of station.
Out of station. Next Thursday. Next Thursday, sir.
Item 27.
May I please, Lordship.
First contempt.
Violation of the
First contempt.
first contempt, my lord.
Follow order follow. First contempt order for the. Yes, 27 टा कौन?
Second of same.
27. First.
28.
Direction to the Tahsildar to take a conclusion, my lord.
28.
Khas mal
28
28 minutes I have permitted to withdraw.
Permitted to withdraw. 28 on the premises that there has been some development in.
No, my lord. I am instructed by the client to withdraw because he has filed another.
Well, counsel for the petitioner doesn't want to press the application.
My lord, is
Dismissed as withdrawn.
28 to the contempt. It first amount.
Co-contempt, Mr. Mahapatra, is 3018.
That is
3018.
3018.
Okay, 3018.
3938.
Okay, 3938
by 20.
3938 टा कौन?
एटा पेंडिंग थिला
एटा काहे ता संगे रहसिला?
एटा पेंडिंग थिला बले सेटा से फाइल कर देले सेटा कर करले. During pendency of this contempt.
नहीं, से contempt रे कौन allegation अछि?
Non compliance of the order.
Okay, first contempt की?
No, yes, my lord, first contempt, first contempt.
First contempt order कर दो। এটা कौन फाइल লাগিলা সামনে এটা
My
সরি
lord, first contempt, my lord.
First contempt
My lord.
Item 29.
29.
first contempt
My lord.
all right
For orders, item 30.
My lord, may kindly see my lord's order dated 5/7/23. On the last occasion, nobody was present for counsel for the petitioner. I
I'm
had
appearing on behalf of Mr. PK Mondi. We have no instructions. Item 30.
कौन हला
Saying no instructions.
माइक रे बिना माइक रे किसी सुनिबनी
Your lordship, I'm appearing on behalf of Mr. PK Mondi. We have no
Yes.
instructions.
counsel for the
adjournment
No, no.
No, no.
का
We have no instructions.
नो इंस्ट्रक्शन का पे पीके महंती पे
Petitioner.
सो जदी नाही ताले रिट पिटिशन कोन पेंडिंग अछि ना ये
My lord, what has happened?
पेंडिंग
During pendency of the writ, my lord.
Here, no instruction कहउचंती dismiss अब why are you wasting your energy fees आराम से enjoy करंतु counsel for the petitioner has no instruction from the party tala the writ petition stand dismissed for no instruction please file a memo
I'll file it in the court of the day.
ना सब लिखि दिया समस्त
My lord, my name also, because I had filed the
अब
intervention.
समस्त ना लिखा हो व्यस्त हंतु मैटर डिसमिस हो सितरे पुनी लड़े
ମୁଁ ନାଟାଲ cause list ରେ ଆଜ୍ଞା ଆସିନି actually ମୁଁ
ହେଲା ଯଦି contest ହବ କରିବେ ନା ନହେଲେ you have to understand where to stop yes 31
Item 31.
Miller.
এটা কোন modification ସବୁ
Miller, I had filed a modification
what modification
of order dated 4 dated 15/11/2019.
କିଛି କିଛି ଶୁଭୁନି ମାଇକ ଉପରେ ଆପଣ ତଳକୁ କହୁଛନ୍ତି
Miller. I
is
have
it a
filed
disposed
for-
case
It is a disposed of case.
it's a disposed case what was the direction in the disposal order
Page 2 of my IA 342/2020.
ଟିକେ ରୁହନ୍ତୁ ଆପଣ କହୁଛନ୍ତି ଏଟା dispose of matter
Miller.
dispose of by which order 26/7/21
15/11/2019. Order 4 dated 15/11/2019. Sir, page 2 of IA 342
ଟିକେ
by
just 1 minute 15/11
2019.
2019
Page 2.
पंद्रह ग्यारह हाँ 15/11
Miller, my limited prayer is that only instructions may be issued to, since it is a covered matter, instructions may be issued to dispose of the case.
but this is a disposed case disposed as withdrawn
Here, direction is issued to file appeal before the appellate court.
हाँ yes with liberty withdraw ହେଇଥିଲା
Miller.
କଣ ହେଲା ତା appeal କଲେନି
appeal न करे modification पे मैं आसीथिले कि तो मु आउ से विषय न जाय खाली I pray honorable court to direct the appellate court to dispose of the case in the light of the
ଆଜ୍ଞା
decision of
ଶୁଣନ୍ତୁ ଆଗ
division
recall
bench.
ହେଲେ ତ ଆଗ 15/11 recall ହେଲେ ଯାଇ ଯାହା କିଛି order ହବ ନା ନାହିଁ
That is
ତ
my
15/11 recall ପାଇଁ ଆପଣ ଏ ମିସ୍ କେସ୍ ଟା ଫାଇଲ କରିଛନ୍ତି 342/20
Miller.
okay let us see that miss case flag B then what is your prayer presently
My prayer is to issue direction to the settlement officer, the appellate court, to dispose of my petition in the light of the decision of the division bench as well as the
so
order of this bench.
is there any pleading in the writ petition on the pendency of the appeal
No, I have not filed appeal. I have filed modification.
so how can that be considered here you may bring a fresh writ petition why are you bringing a miss case see the council the petition has been permitted to be withdrawn to pursue other remedy available
But
you have in the meantime pursued the other remedy सेटा गोटे मिस केस टे फाइल कर देबे अर्लियर ऑर्डर टे को मॉडिफाई करके एटा बर्तन कहि दियंतु अपील सर जीवो
सेतेबेले सही पोजीशन रे
sorry
I have
this
filed.
case not entertainable in the background of the case that the writ petition is already dismissed as permitted to be withdrawn
Miller, liberty,
Petitioner, if he has a cause of action, may bring a fresh writ petition.
press, Miller.
Next is.
Item 32. Restoration of the application which has been dismissed on 14th.
Condonation of delay.
Yes, ma'am.
Notice has been issued.
No, my lord, notice.
First time.
First time.
What is the delay? And who are the opposite parties?
All the opposite parties are
The other
BDA.
proceeding was dismissed after notice. So I am
OP5.
not serving copy on the other side count.
OP5 is the private opposite party.
They change copy tango.
No, no.
It is OP5. OP5 aguru appear karnathile. In the read petition, OP5 had not appeared.
No, man.
But notice was issued.
Yes.
Okay, then limitation day OP5 ku notice jibo.
Yeah.
Notice in the limitation. Requisites as undertaken be filed by Monday.
No.
Notice be issued fixing short returnable date. Matter may be placed immediately after appearance of the
1 to 4 I will serve copy. 1 to 4 is the
memo file kar diyantu. They have received, therefore no notice be issued. In the event, counsels for OP4, since they have already appeared in the read petition, accept the copy of petition. It is open to the petitioner to file requisites only in respect of OP5. Yes. Yes, 33.
Item 33.
Yes, 33 requisites can file late.
Late, sorry.
ଆପଣ କାଇଁ argue କରୁଛନ୍ତି?
No, sir.
Junior କାହାନ୍ତି ଆପଣଙ୍କର?
Because
Yes, late
late-
file, requisites filed late accepted.
The Lordship, may I only point out one thing, item 33.
Item 33, yes.
My lords, here, Lordship, this prayer is not maintainable, your Lordship. Because your Lordship may see what is under challenge.
Notice direction already ହେଇସାରିଛି କଣ କରିବା?
In fact, the letter that my learned senior has challenged, that is based on a scheme of the Mission Shakti department, your Lordship. That scheme has to be challenged. This is just a consequential letter.
ଆସୁ regularize ହେଇକି ଆସୁ. Once notice direction ହେଇଯାଇଛି ଏବେ final କରିବା ଠିକ ହବନି. Yes.
Item 34.
May I please your lordship?
What is this modification?
My lord, in last occasion, your lordship was directed to conclude the demarcation case 37/23 within 6 weeks. But in fact, in the order sheet, it is reflected 6 months.
Okay. There is inadvertent mentioning of time disposal of the demarcation case 37/23. Word 6 months, words 6 months, inverted comma, stand deleted and replaced by 6 weeks from today.
Much obliged.
In this case, stand disposed.
Item 35.
Hey, Dalenga matter ta kar do, place the matter immediately after service of notice. Huh? Yes, 35. Yes, inadvertent typing achala, correction kar do. Right. Yes, 36, who is there?
My lord, this relating
opposite
to,
party has expired in the meantime.
I have added his sons.
Huh?
Other legal heirs I have added, my lord, OPs.
There is no necessity of substitution.
No, my lord, no.
Which party has died?
4, 5,
Number
6.
4. Then who is there to represent him?
This son is 5 number, 5 is 6.
5 is there.
7.
Okay, see, Das makes a statement that for there is already legal error of OP number 4 by way of OP number 5.
5, 6, 7.
There is no need to substitute.
My lord, this relates to that regulation 2. Transaction was made in the year, Lordship may say, annexed to page 10. Permission was granted by the competent authority in 98.
Yes.
And immediately within a month,
1998?
1998.
1998, 98.
1998.
Okay. Date टा कौन आती कहेंगे? Year
Yeah.
कहते
27th January 1998.
27/1/98.
Then registered sale deed was executed on 31st January 1998. Then in 2000, so moto proceeding by the Annex 3 is initiated by the collector.
How about the 5 years ଭିତରେ ହେଇ
Restoration. Kintu fully covered under the Jami Ramesh case. Paragraph 12 clearly says Jami Ramesh. That judgment here, my lord.
Right. Yeah.
Paragraph 12 is clear.
Who appears for OP5?
Nobody. Notice galaani 2018 ରୁ ଆଜ୍ଞା କେହି ରେଗୁଲେସନ 2 ରେ ନର୍ମାଲି ଲର୍ଡସିପ ନୋଜ ଖାତାଦାର ମାନେ ଆପ୍ରିୟ କରୁନାହାନ୍ତି।
appear କରୁଛି।
କେହି କରୁନାହାନ୍ତି।
Notice substance ହେଇଛି କି ନାହିଁ?
ଆଜ୍ଞା ଆଜ୍ଞା। Lordship may see the judgment. I have just handed over court master.
In spite of sufficiency notice on OP number 5 and 6, nobody is appearing.
That where my lord the ultra virus of particular amendment provision was challenged and the amendment has no retrospective effect, that paragraph 12 is clear.
All right, considering the rival contentions of the parties, this court records there is no dispute that the case at hand is squarely covered by more ଅଛି order ଦଉନ
ଆଜ୍ଞା ଆଜ୍ଞା ସେଇଟା ମୁଁ ଭୁଲି ଯାଇଛି ଭୁଲେ ଆଉ ଗୋଟେ ଜଜମେଣ୍ଟ ଟା ନେଇ
by a division bench judgment in the case of so and so reported in 2000 in the case of so and so along with number of similar cases reported in 2019 volume 2 ILR Cutoff 272 in the circumstance and for the
para 12
outcome in the decision referred to herein, this court find the proceeding initiated herein was without was not maintainable. Considering the amendment involved is a prospective one. In this circumstance, this court interferes in the impugned order. Annex so and so set aside.
Annex 3.
Read petition succeed.
Obliged.
Item 37.
ଆସନ୍ତୁ ମିଷ୍ଟର ବିଦ୍ୟାଧର ମିଶ୍ର ବ୍ୟସ୍ତ ହଉଥିଲେ।
My lord, the dispute in the present case relates to Sarpanch post of Palada Gram Panchayat of Nischint Koili block.
ଅଛନ୍ତି both side ଅଛନ୍ତି।
In this case, the complete deposition has not been filed. Which complete deposition has not been filed by the petitioner, my lord, in which the statement made against them, my lord. That
complete deposition file ହେଇନି?
My lord.
କାଇଁ ଦଉନାହାନ୍ତି କପି? ଆପଣ ଦିଅନ୍ତୁ, ଆପଣ ରିଲାଇ କରୁଛନ୍ତି ତ? ଆପଣ ଦିଅନ୍ତୁ। ଫାଇଲ ନହେଲେ ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟରେ ଆପଣ ସେଟା ଦେଖେଇବେ, ଦେବେ, କପିଟେ ଦେଇଦେବେ, ଆମେ we can consider. So matter will not wait. This is the election dispute.
My lord.
So are you ready?
My lord, Mr. Mulia will argue the case, my lord. Mr.
Then
Yes,
why are you making him wait? ତାକୁ ରିକ୍ୱେଷ୍ଟ କଲେନି ଆଜ୍ଞା ଆମକୁ ଆର୍ଗୁମେଣ୍ଟ କରିବେ, ଆପଣ କାହିଁ ସାର୍ ବସିଛନ୍ତି ସିନିୟର ଓକିଲ, କାଲି କରିବା କି ସୋମବାର କରିବା ସେତକ ଆମେ କହିପାରିବେନି?
Sir, 5 ଥର ହେଲାଣି।
ରିଚ୍ କରି ରିଚ୍ କରିଛି।
କୋଉଠି ଅଛନ୍ତି ସେ?
First sir, ଯେତେବେଳେ
ଆସିବେ, ମୁଁ ଆଉ ଗୋଟେ ମ୍ୟାଟର ଶୁଣିଲା ପରେ ଆସିପାରିବେ କି? ପାସ୍ ଓଭର କରୁଛି।
ଆଜ୍ଞା, I am waiting.
Item 38.
This matter, as suggested by my learned friend and advised by your lordship, I went and met secretary of the BT.
Yes.
Upon discussion, the secretary agreed that this is directly covered by your lordship's earlier judgment in Sashwati Panda's case. Frankly, can be disposed of in terms of that judgment.
ଅଛି judgment copy ଅଛି।
And I've made some minor pencil corrections on that, about the dates and names of parties, etc. The lordship may try and go to that.
Just have a little background.
Manoj, in the year 2007, I was looking for a plot of land in Bhubaneswar and came across one Dr. What was it? Jagannath Mahapatra, who was an allottee of a plot of land in the district center Chandrasekhar. We discussed the matter, agreed to the sale price, and Mr. Jagannath Mahapatra applied to the BDA for permission to sell. I paid my own.
Pre-possession or post-possession?
He was in possession. Possession was granted.
So post-possession.
Post-possession. But no deed was done. Yes, it's admitted in the counter affidavit.
No, he admits us. Post-possession.
Post-possession.
Counter affidavit is admitted, date is given. Now,
no, the government circular also I enclosed
Just
about
one
Annexure B by 2. Annexure B by 2 minors to my counter. Or kind of a class. The government made this clarification concerning post-possession.
Page.
Page
B
9
by 2.
minors. Annexure B by 2 by counter.
B by 2.
Of my counter.
Yeah.
Government after careful consideration.
Government
after careful consideration have been pleased to decide the exclusion of the names of the allottees, getting only one plot, house, plot.
Okay, just 1 minute. B by 2. To?
B by 2 is 10.
Page?
Yes, 10.
Sorry. There are a number of counters probably.
No, one counter.
It a counter by OP2.
Counter by OP2.
OP2.
Minutes.
Then B by 2 is page 15.
Page 15.
15.
So the page last portion. Government relaxed post position.
Just 1 minute. Para general administration.
General administration.
Clause 3.
Last portion. Government after careful consideration.
I'm not quite clear which page my learning figure.
No, tally koruni.
Page 10.
Tally koruni.
Page nahi jo eta notification GA department notification
eta 30 January 2015.
No, 8th December 22.
No, tale out
Annexure B by 2.
B by 2 Bombay.
Yes.
This is the only annexure here.
Yes. Annexure B by 2 series. That is a series, there are number of annexures, but first annexure B by 2, page 9.
First annexure.
Page 9, page 10.
Page 11, page
10.
Page 10.
Yes.
Government after careful
consideration have been pleased to decide for exclusion of the name of the allottees, getting only one plot, house, plot, which means, and by following the prescribed procedure provisions and for transfer of such allotment in favor of the legal layers of the original allotee.
This supports the petition.
The only thing is that, my lords, I put for clarification by writing this, they limited it to only legal layers. The GA department limited it to legal layers only.
Where is that restriction?
That restriction I'm reading, my lords. Next one, last person. Provisions and for transfer of such allotment in favor of legal layers and the of the original allotee. Because pre-possession and post-possession usually means my lords, so far third party is concerned. Now the GA department says that it should be limited to only legal.
Clarify.
My lords.
This restriction will not apply in his case.
Yes, that so far because pre-possession and post-possession are mostly.
So it is pending for your decision. Oh, for an agreement in between you and the third party. For an agreement in between you and the third party. So, Mr. Mahanti, that ends the matter.
I'm not quite clear what my learned is trying to bring to Lordship's notice. In this case, the language uses Jagannath Mahapatra applied for permission for transfer. What the BDA has done, they've cancelled the allotment in his favor and made a fresh allotment in my favor. So frankly, it's not even a third-party transfer. It's a fresh allotment in my favor. And I paid a 50,000 rupees processing charge, which really is a euphemism.
So therefore, for you, there should not be any hindrance in entering into agreement.
That's right, much surprised.
So that's the
probably if I'll be going in that way, my lords, then my lords, it will be a difficult proposition. But the only thing is that it is a pre-possession transfer. The pre-possession transfer, what the government says is it is applicable to legal heirs only.
Legal heirs only, but
But
that,
minors are already, minors are.
there cannot be such restriction.
That's it. But this much minors will do, it will help many and minors, minor seniors problem will be solved. Immediately, minors may direct also the BDA to the initiate process of execution of the lease.
So he is referring to my judgment where I have
Yes.
said the
Yes, yes.
post-possession transfer is valid.
Post-possession and
If-
pre-possession also minors are directed.
Okay.
The
Therefore, this decision will also come to his rescue.
Yes, minors.
Further,
Yes.
this clause will not stand on the way.
Minors. Minors may
This
clarify.
clause will not stand on the way.
Minors decision concerning pre-possession is WPC 186, sorry, 18169 of 2023. 18169, 2023, dated matter 7/7/2023.
He just didn't tell you.
Yeah.
That is also in a way to help the third party.
Jyoti
transfer.
Prakash Mishra and all this. Well, that will solve the purpose. Let us not enter into all these types.
So I'll refer these two judgments
Minors.
and I'll say this restriction should not, it's a arbitrary restriction.
Arbitrary.
If it is applicable to legal heir, why not to the original?
Original.
ତାମାନେ ସେ ଅପେକ୍ଷା କରିବେ legal heir
Means
ଯେତେବେଳେ apply
you-
ହବ ସେତେବେଳେ ତାଙ୍କୁ ଦିଆହବ।
Well, no, question is not that. Question is that somebody died, then legal heirs will get it. But somebody during lifetime sold the property.
And he can't take. खाली observation टा रखो, it's a strange thing. The claim of the petitioner is being obstructed by virtue of Odisha Gazette publication dated 30th December 2022, which whereby government has been extended the benefit of post-possession transfer, however, by only in favor of the legal heirs. Considering the factual backdrop involving herein, this court find the present issue involved a transfer between the original allotee and the party in interest, the petitioner. There has been certain compliances seeking the transfer in the meantime by way of deposit, required deposit even. In the circumstance, in the meantime, there has been also a number of judgments of this court taking out the restrictions in the transfer of properties or and entering into appropriate agreements.
Lease deed.
Both
Appropriate lease deed.
lease deed, both in the case of pre-possession as well as post-possession cases. Considering the obstruction in the hand of the development authority in view of the restriction in the Gazette notification dated 30th December 2022, Annexure B/2, page 9, running page 135 of the brief. This court find the relaxation granted therein reads as follows. Quote kariba, page 10 rachi 136 bracket rakho. This court here looking to the factual scenario, the judgments of this court and the factual scenario involved herein finds the petitioner case stands in a better footing as there is direct creation of lease document in between the original allotee and the transferee.
Original allotee and the transfer is not executed.
Transferee, he is the transferee.
Original allotee has not executed the lease deed in favor of the transferee because original allotee didn't get that lease deed from BDA. Now direct lease deed will be executed.
Direct lease
Will be executed in favor of my landlord.
He is dead now.
Yes.
He is dead now.
The petitioner,
No, original allotee.
original allotee probably dead now.
Now there is no necessity.
Because of minor's decision. So for
You can stay to enter into agreement.
Yes,
with
you
him.
can stay to enter into the lease deed,
Okay, all
comply
right.
with the conditions of bundle
This
of
court
life.
find the granting of relaxation through this Gazette notification only in favor of legal heirs of original allotee may not be appropriate, as in number of cases, the original allotee still survives. In the circumstance and for the outcome already in the read petitions 18169 of 23 disposed of on 7723
And
as well as WPC
yes.
12489 sub WPC over 12489 of 22 disposed of on 121022. This court allowing the writ application commands the development authority to in allowing the request of the petitioner to enter into
Execute the lease deed.
appropriate lease deed by completing the entire exercise at least within a period of 2 weeks hence,
Slightest more time.
3 weeks, 3 weeks hence. Petitioner undertakes to
Comply all other.
work out any other statutory compliances, if
Right.
any there.
Yes.
Read petition succeed,
Right.
no cost. ସବୁ କେସରେ ମିଷ୍ଟର ମହାନ୍ତି ଗୋଟେ ଦିନ ଥାଏ ସରିବା ପାଇଁ। ତ ସେ ଦିନ ନ ଆସିଲେ ସରିବନି, ସେ ବେଳା ସେ ଦିନ।
My only anxiety is my life lease is ending very fast. So
ମୁଁ ଦେଖୁଛି ଆପଣ ସକାଳୁ ବସିଛନ୍ତି କିନ୍ତୁ I am helpless, I am going one after another
I
matter.
happily understand.
And everybody is anxious to see that there is some outcome in their case.
I understand.
So I can't leave any matter to touch you.
Much obliged.
Incidentally, I have assisted him in some many cases.
I have the honor of
Yes.
My lord, dispute
Pass
in,
over.
Item 37.
dispute in the present case relates to Sarpanch post of Palada Gram Panchayat
See you later, other side.
of Nishinta Koili block
Hmm.
in the district of
Now,
Kota.
Crocs ko asundu, Crocs ko asundu.
Okay.
What is the challenge here?
Challenge here, my application after I lost the election with 2 votes, margin of 2 votes. After close of evidence, I filed an application for recounting, inspection and recounting. Call for the ballot papers, inspection and recounting. That has been rejected by the.
But what is the necessity of filing such a petition? Mr. Biswanath, please
My lord.
understand. For that allegation to be adjudicated in an election proceeding, you must have a specific pleading in your pleading.
My lord, all the requirements I have complied with.
Okay. So having a pleading in that line,
My lord.
you must have laid evidence also to that.
Exact, my lord is absolutely.
Then the Supreme Court judgment I have incorporated in my judgment.
My
In
lord,
the
my-
event there is specific pleading
Right.
and corroborated with evidence,
Evidence.
the only course open is to give a direction
My lord.
for recounting.
My lord.
But that normally takes place when the judgment flows.
Again,
Because unless he set himself to the judgment process,
my lord.
he can't come to such a conclusion.
My lord.
He has to pass a interim judgment and there he has to give a direction for recounting.
My lord.
Subject to outcome in the recounting, he has to close his judgment. He has to close his judgment. So why you filed an application?
Relying upon the existing judgments?
That's right. No application was necessary.
necessary.
Then I can clarify only, even though the application is rejected,
My-
the court may proceed for the judgment and in the event find substance in the pleading corroborated with evidence,
My-
will follow the decision of this court.
My lord may come to 11E at page 19. I have exactly shown those things.
11
Paragraph 11E, page 19 of the brief.
of the brief.
My lord. What your lordship is stating, I have exactly presented this.
So there is mind matching.
My lord.
So there is mind matching.
Mind. Mind match.
ନାଇଁ କିଛି ଇଲେକ୍ସନ କେସ୍ ଆପଣଙ୍କଠୁ ଆମେ ଶିଖିଛୁ।
ଆଜ୍ଞା। ଆପଣଙ୍କ ଜଜମେଣ୍ଟ କୁ ଫଲୋ କରିଛୁ?
ଆପଣ ମତେ ଫଲୋ କରିପାରିଲେନି। ଇଲେକ୍ସନ କେସ୍ ର କିଛି ପାଠ ଆପଣଙ୍କଠୁ ଆମେ ଶିଖିଛୁ।
ଆଜ୍ଞା।
ଆପଣଙ୍କ ଦ୍ୱାରା ତିଆରି ହେଇଥିବା ଜଜମେଣ୍ଟ
ଆଜ୍ଞା
ରୁ ମଧ୍ୟ ଶିଖିଛୁ।
ଆଜ୍ଞା
Yes, what is there? If pleadings are there, my judgment is well supported.
No, my lord, not supported with the lordship judgment, my lord. Lordship judgment very clear.
I am not observing anything.
Yes,
I will simply say, this is the judgment of this court,
yes,
followed by a Supreme Court judgment.
ma'am.
So he is to look into the pleadings,
And evidence.
at the same time also evidence, and take a decision on the recounting,
yes, ma'am.
while continuing with the judgment.
Ma'am.
So this order will go.
Ma'am.
This order will go.
With a great respect, my learned senior, my learned senior have not filed the complete evidence of my lord. PW1, my lord, Sujana Malik. My learned.
Don't argue here.
Yes.
You must have argued.
Yes, sorry.
Argument commence kolaani na nahi?
No, my lord, sorry.
Argument is sort of
Yes, yes.
I should not express any opinion there.
Yes, my lord, sir.
He has a duty
Yes, ma'am.
on him to give a verdict on the recounting, because this is based on recounting only.
Yes, ma'am. Yes, ma'am. Yes, lordship is, ma'am.
Therefore, you will take out that right. Take away, the court will take away that right before passing judgment. It's not permissible.
Exactly.
କୋଉଟା most appropriate decision ଏଇଟା ଏଇ ଯୋଉ ଅଛି ଦିଟା decision ଅଛି ଗୋଟେ ବୋଧେ two votes difference ଥିଲା ଗୋଟେ one vote difference. So ଦିଟା judgment refer
Supreme Court.
all right, I am reserving, I will give a judgment.
My lord.
Decisions we are giving.
I have supplied.
Ma'am.
ଦିଟା decision ଏଇଟା ଅଛି.
All other decision it had also supplied.
Supreme Court decision.
All other decisions are.
Supreme Court decision भी ଅଛି.
Yes.
And the division bench decision of this honorable court is also there, last item.
ଟିକେ ମାଇକ୍ ଇଏ ବନ୍ଦ କରିବ ଲାଇଭ କରାଯିବ. Sometimes it hurts us seriously. ସେଥିପାଇଁ ଠାକୁର ଶୀଘ୍ର ମୋ ତାରିଖ ପଳେଇ ଆସୁ.
ଦିଟା ସମାନ ଅଛି.
ସରିଗଲା ତ ଚାଲ ପଳେଇବା.